crimes already have exemptions established and a precedent has already been established, or is this indeed the first of its kind?
Well, because the way it's written, sworn law enforcement can get those records upon request. So all these other crimes are generally investigated by state certified law enforcement officers. I'm just in a very unique position. I'm not a state certified police officer, so I can't get those records. So any of the other crimes, whether they be whatever crime it might be, they're usually by real police officers working the case.
Thank you.
Thank you, sir.
Representative Trotter.
Thank you, Mr. Chair. Thank you for taking my questions. You testified that you work with law enforcement on these investigations now. And if that's so, are they able to get these records and share them with you? Or if they do get these records for their part of the investigation, are they not able to share them with you?
When I say I work with other law enforcement agencies, they're generally not on my open cases. So let's, for example, today, we just talked a moment ago about the vehicle that went off the side of the road. It was pulling a trailer and it flipped over, and I have access to all those records. I'll get a copy of the insurance claims file. We'll do our interviews with the people. We get a copy of the accident report. I'm really not involving law enforcement in that case. There's no reason to, because there's nothing that they can do that I can't do. I'm just going to do the same interviews. So when I say I work with law enforcement, it might be, I have a case of an insurance producer stealing $200,000 from his customers, and it's a case that the FBI would be interested. I'll work hand in hand with the FBI in a case like that. If I'm doing a search warrant on somebody's premises or on a building, because I'm not an officer can execute a search warrant, I'll work with law enforcement then. But for the most part, I would say 90% of my cases I do without the assistance of any police.
Other questions? Representative Langley.
Thank you, Mr. Chair, and thank you for taking my question. At any point, has there ever been any consideration to expand your job description and your role to have you become a state certified police officer?
Thank you for your question. I've been with the unit now for about 15 years, and I can say that there's never been any discussion about making us sworn police officers.
Thank you.
Other questions? Seeing none, thank you for your testimony today.
Thank you. Thank you, everyone.
Is there anyone else who would like to testify on Senate Bill 288? We have a representative from 911. Would you like to let us know what impact this might have on 911?
Is it on now? It is. For the record, my name is Mark Doyle. I'm the Director of the Division of Emergency Services and Communications, overseeing New Hampshire's enhanced 911 system with the Department of Safety. And a lot of questions came up that were posed to the Insurance Department regarding the nature of the data that we have, what type of data we are asked to share right now. And for the record, the Department of Safety has no position on the amendment as it stands. We're neither pro nor con. However, we just want to make sure that when any of these types of cases come up, as had been already alluded to by one of the representatives on the committee, could this potentially be a slippery slope? What's the nature of the information that's going to be shared? We've heard testimony before regarding, I think, environmental services when they came before the committee to talk a little bit about sharing address information. We want to make sure that whatever the information is that we're sharing is information that's going to be, number one, pertinent to the nature of the request, and secondly, is going to be protected at all costs, because as we've discussed before, a lot of that information was obtained through a lot of, I want to say a lot of heartache, but there were a lot of concerns way back in the day when E911 went forward with collecting and maintaining the databases where a lot of this information is stored. Long story short, when we spoke to the folks at the Insurance Department about what it is that they wanted to do, we recognized that there was this little bit of a gap between what constitutes a request from a certified law enforcement officer versus what constitutes the request from an individual who's conducting a criminal investigation and needs that same information. So we wanted to make sure, again, that it's pertinent to the request and that the information, whatever it is that they're requesting, is going to be protected at all costs. And it's going to be provided within very strict guardrails. So when we've had the conversation with the folks from the insurance department, we did our own digging to make sure that those 2 points are going to be addressed completely. And we do recognize that there are statutes in place relative to the protection of the information, that it's not subject to right to know, that it is going to be handled in much the same way law enforcement officials around the state maintain evidence and dispose of evidence, whether it's information or physical evidence. And we've got those assurances not only from the insurance department, but they're built into statute. Along with that, the statute requires that the insurance department work closely with the Attorney General's office whenever they conduct a criminal investigation. So we've got that nexus between the insurance department as well as a law enforcement agency when they're conducting these investigations. So we've got assurances that not only is it going to be specific to a criminal investigation, not unlike a law enforcement investigation, that information is also going to be protected. So we don't have any heartburn anymore about where that may end up, that it's not going to be out there in the public domain, that it's going to be very well protected at the insurance department based upon the best practices they have in place when it comes to maintaining that data and holding it and disposing of it when it needs to be disposed of. They're only looking for right now, and correct me if I'm wrong, information related to the timing of the call and the actual call itself. They're not looking for address information or any of that other data. However, that information may come pursuant to the criminal investigation that follows up, whether it's with a law enforcement agency outside of the Attorney General's office or the Attorney General's office themselves, which can then obtain any further data that they require. So again, just from the Department of Safety's perspective, we don't take a position on the bill, but we do feel comfortable and confident that the information that they're looking for is specific to the statute and within the narrow guardrails associated with the request right now is based upon the wording of the amendment.
Representative Smith.
Thank you. Would this change require rulemaking?
It would. We had just gone through that last year to change Chapter 106H and the rules associated with SAF-C 7000 through 7013, which is specific to the Division of Emergency Services and Communications. So we would have to go through rulemaking to address that.
Thank you.
Other questions? Representative Notter.
Hi, thank you. Thank you for taking the question. I'm still trying to make sense of the question that came through from a viewer. So yes, there is a section 3, but it doesn't say the words regardless of the use of such information under paragraph 1 and 2. So wording is important. Should those words be included? I'll read them again. Regardless of the use of such information under paragraph 1 or 2.
Thank you for your question, Representative. If I could look at the wording of the amendment. So the new paragraph to be added regarding the information not subject to right to know through the enhanced 911 system states to the insurance department in connection with an ongoing criminal investigation related to insurance fraud or other insurance related criminal activity. And this would be added in addition to, but not replace any other wording.
Thank you.
Other questions? Representative Di Lorenzo.
Thank you, Mr. Chair, and thank you for taking my question. You know, in the Senate hearing, some testimony was given that by the insurance department that under this bill, by statute, all of the records would be kept as confidential and then they would be destroyed after 6 years. But are we talking paper records just being destroyed or internet records, electronic records?
Thank you for your question, and I believe all records refers to not only paper but electronic as well. So if we were to provide a recording, which in some cases we would, in pursuant to a request for the data relative to a criminal investigation, any records that we would provide would be destroyed, whether they're electronic, whether they're paper, hard copy, or otherwise.
Thank you.
Representative Chase.
Thank you, Mr. Chair, and thank you for taking my question. It might have been asked already, but how often does this happen that the need, I probably should have asked the other gentleman, I'm sorry, but the need to try to obtain these records?
Thank you for your question. And regarding the insurance department, I believe our discussions have been about a half a dozen times a year, plus or minus. However, other law enforcement agencies will request them regularly. And I know the question came up earlier about the process and what that process looks like. We have a standard process that we would ask. We do ask any law enforcement agency, and we would bring up to speed the folks in the insurance department, should this amendment pass, that there is a process in place that they have to fill out a form. We keep a record of that form. We keep a copy of the information that we supply as well, so that there's an audit trail associated with whomever it is that we provision that information or data to. So if somebody needed to look back, for example, to find out what was requested by whom and when, we have that information in addition to the folks, to whomever it is that we provision that information to.
Other questions? Seeing none, thank you for your testimony. Would you mind filling out just a pink card so we can have that on the record as well?
Certainly, Mr. Chair. Thank you very much.
Thank you so much.
Thank you all.
Is there anyone else who'd like to testify on Senate Bill 388? Seeing none, we will close the hearing on Senate Bill 388 and move on to our next item of business. Actually, we gotta wait a couple of minutes, I guess, to do that.
All right, I'll let you get back to whenever you have a minute, though, and I'll be across the hall in education. So anytime you want to stop over. Sorry to interrupt you. All right.
Take care, Mr. Chair. We'll call the committee back to order. Our next item of business is a hearing on Senate Bill 216. This is a bill establishing a commission to study the landlord and tenant mediation program in circuit courts, and we'll call upon the primary sponsor, Senator Perkins Quokka.
Good morning, everyone.
And I'll try to be more kind to you than I was the last time you appeared before the committee, so.
You know what, Chair? It was an unexpected situation. No problem. Good morning, everyone. It's nice to be here with you. For the record, I am Senator Rebecca Perkins Quokka from Senate District 21, representing the city of Portsmouth and the towns of Madbury, Lee, Durham, Newington, Newmarket, and Newfields. The prime sponsor of SB 216, establishing a commission to study the landlord and tenant mediation in circuit court. SB 216 will create a commission to study the landlord-tenant mediation pilot program currently ongoing in the circuit courts. Working with Judge David King and his staff, the circuit courts have developed this new program in order to work through issues between landlords and tenants while trying to avoid evictions. We all understand how important housing is, especially after the last year and a half, and SB 216 will give the general court and all relevant stakeholders an appropriate venue to analyze the program, assess what has worked and what hasn't, and make recommendations and changes for the program going forward. SB 216 passed the Senate Commerce Committee 5-0 and passed the full Senate on the consent calendar. Mr. Chairman, I'm going to leave it at that. Thank you for the opportunity to present, and I'm happy to try to answer any questions.
Are there any questions for the senator? It's your lucky day.
Well, that's too easy. Thank you so
Thank
much.
you. Whoa, sorry. Representative,
I'll have to change that.
You
Thank
are-
you, Mr. Chair, and thank you, Senator Cloker. So tell us more about the pilot program. I know that tell us more about it.
Sure. Yeah,
How
thank
did
you.
it start?
Yeah, thank you, Representative Lorenzo. And I neglected to mention in my introduction that Representative Lorenzo and I actually worked very closely together on this bill. We had several Zooms back in the summer and fall of last year with the judge's office to make sure that this was something they wanted us to take up and to see how we could assist. So the landlord-tenant mediation program has been ongoing for almost a year. I believe Richard's going to come correct me anything I say wrong. And thus far has been successful at keeping up to 80% of the tenants who have come through their program in their homes. So it's been a really successful program. And what the Honorable Judge King has found is that a lot of times the court doesn't have an opportunity to simply sort of give air to the issues that have arisen between the landlord and tenant pursuant to formal procedure. So this mediation program has given a chance for the parties primarily to do the work to sort of, work out these issues between them in a formal setting, and in that way allows the court to actively support them, resolving these disputes in a new way that's not as procedurally stringent. So I guess those are the highlights to me. But I think, making sure that the general court kind of takes a look at this model and, potentially considers how it can further be expanded in the future would be a smart use of taxpayer money and a great way to avoid formal litigation where we could be supporting, more resolution of these disputes outside of the court, and also accomplishing our important goal of making sure people stay in their homes so they can focus on their families and their jobs and being a part of our society. So.
Representative Chase.
Thank you, Mr. Chair, and thank you,
Yeah.
Senator, for taking my question. I'm just looking at real quick through your report, but seeing this is a pilot program and we're looking to make it a commission to study, when is the pilot program going to end, and do you foresee some issues between that and hopefully getting the study up and running?
Yeah. I am going to defer the question on when it ends. I believe it is later this spring that it will come to an end, but that's part of why we thought the commission would be well timed, because it would give an opportunity for other stakeholders, such as New Hampshire Legal Assistance and New Hampshire Housing, just to be a part of the conversation on this program and make sure it's the best it can be. Thank you.
Other questions?
I see Representative Smith.
Representative Smith, out of the corner of my eye.
Thank you. Thank you, Senator. If the pilot program has been so successful, why haven't you come to us with legislation to make it permanent rather than to set up a commission?
That is a very good question, Representative, and I'll let Mr. Head speak to this further. But Representative Lorenzo and I did ask if that would be a helpful way to support the program, and given that the pilot had not even yet come to conclusion, the judge's office felt that it would be better to give the pilot program a chance to run its course. But I felt that having a commission to make sure we, as the general court, supported the program might be a good way to then come back next year, perhaps with a request for appropriation to make it permanent. Thank you.
Other questions? Seeing none. Again, thank you for your testimony today.
All right. Thank you all very much.
Richard Head.
Good morning, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch, and the chair did not say, but I did sign up in support of this bill, and the Judicial Branch does support the bill. I just wanted to, and I also am apologizing on behalf of Margaret Huang, who does all of our alternative dispute resolution coordination. She had a conflict this morning, so if I cannot answer a question, I'm happy to get an answer for you. This program originally started in 2 courts as a pilot with existing funds that we have out of our mediation budget. As a result of the availability of federal funds through COVID relief money, we were able to expand the program so that it currently has 2 separate parts to it. One is a pre-filing program to encourage a resolution prior to any filing of any litigation in court. And the parties, either any party involved can reach out to the court. We do a sort of an intake process. If there are resources that we're aware of that can be of assistance to the parties, we make the parties aware of those resources, and then we try to resolve any disputes prior to any litigation being filed. With the data that we have, that has in the fairly small window of time that I have data here, November of 2021 through February of 2022, that had about a 68% success rate on reaching agreement in pre-litigation matters. And then we have a separate program in the pre-litigation is statewide. You can do that anywhere in the state. The smaller program we have is post-litigation. So when it's actually now been filed in the circuit court in Concord, Nashua, and Manchester, we're running a separate program where all of the parties are offered mediation essentially on the day that they would have their scheduled hearing. So when they're at court for their hearing, they're given the opportunity to be redirected into a mediation and try to resolve that short of appearing in front of the judge. That has the advantage for the parties of letting them be in control of what the decision is. It does not always result in a tenant staying in the apartment, but it may result in a process by which the tenant will leave the apartment as opposed to having a date certain. It avoids the uncertainty of going to a judge and making a judge decide on the matter. And it gives the decision making over the case, that authority over to the parties. And what we've seen, again, in a relatively small window, about an 81% agreement rate on those types of cases. So a very successful mediation program in that sense, but it's a fairly small group of cases so far. So relatively new program. Because we're able to do it through ARPA money, we do have additional time. So we're hoping to extend this program through the year. What I think the study commission would do would give an opportunity for us both to provide information to the legislative body, because if you do want to extend this program, it would be a budget item next year. So one, it's an opportunity to sort of educate the legislative body on the program. It's received national attention. It is a very positive program. But if we're asking for money, it's a useful thing to provide information. It's also useful to the judicial branch because we can always improve things. So if there's testimony, if there's a process by which we would receive information about how we can improve the program, we're always interested in that also. So I think it does have a benefit. We're not in a budget year, so we're not asking for the budgeting items this year, but we think we have federal funds available sufficient to carry us through the year. So that would provide the overall benefit. And with that, I think I'll conclude my testimony and be happy to answer any questions.
Representative Chase.
Thank you, Mr. Chair, and thank you, Attorney Head, for taking my question. Just out of curiosity, because this is a pilot program and I'm looking at where the filing, or is it Concord, Manchester, Nashua?
That's correct.
That's the only area, so if you lived in Portsmouth, you wouldn't be able to use this program right now?
That's right. So what we do is we're paying the mediators out of the federal funds or out of our mediation budget, so the parties don't pay for it. But because those are in the courtroom, they're physically there. It's a limited amount of funds available. We're able to do the pre-litigation one statewide because those are done remotely, either video or telephone. So, in that process, we're able to offer it more broadly, but because these are physically done in the courtrooms or in the courthouses, it's a more limited program. And then we pay for the cost of the mediators out of our program money.
Yeah, Representative Chase, you want to follow up?
Thank you. So this is just where, I just want to understand all of this, where the courts are being heard. But if, say, you lived in Portsmouth or my hometown, Rollinsford, and I had an issue, I would be able to file and go to one of these courts that this is happening in?
No, what would be available would be the pre-litigation. So the parties who are not yet filed lawsuits, if your normal place to file a lawsuit would be Portsmouth, this program is not available in the courthouse there, but anybody would be able to reach out, call the telephone number that's on our website before litigation, and try to do essentially a remote mediation.
Other questions? I guess I do. So and it sort of gets back to what Representative Smith asked, and you've given us all the reasons why the program is working and why it's successful and how it benefits both tenants and landlords. The question, I guess, is what is ultimately the purpose of the commission? Is it more than showing that the program is successful?
Thank you for the question. I think the benefit would be that as we are developing this program, because it is a new program, I think the legislative body does provide sort of a unique form for ways in which it can be improved. So it does allow the public an opportunity to come and speak to the program where they may not give us feedback in the same way. It gives legislators an opportunity to give us feedback so that the program itself may be modified through this process from what we're doing currently. But certainly I think the goal is to provide information about the program, but also receive information about what do we do well, what can we do better, and what other input can we get that we might not otherwise receive.
And if I could ask a second question, and I was just in another hearing prior to us meeting this morning where talking to representatives from the court who basically said we can't accomplish everything that we currently are doing. We just don't have the resources or the ability to do that. Is it under those circumstances, do you think it's advisable to take on an additional or a new program?
So thank you for the question. I think there are definitely resource issues. We have staffing issues in all of the courthouses. We are currently down 2 full-time judges in terms of having folks who have retired but not been replaced. We have a marital master who is about to retire and has not been replaced. We have definite shortages in the circuit court system, and that does result in delays. The benefit of this program is, one, it's operated and managed out of our alternative dispute resolution program, not by the court clerks. It is managed with mediators as opposed to judges or court staff. So we have third-party mediators who are filling that role. And at the end of the day, it takes a certain number of cases out of the system if they're able to be resolved pre-filing, which is ideal. It never enters the court system, or if it's entered the court system, it at least does not result in a hearing. Relatively, and this is obviously part of the discussion, once you're in a filing has occurred and we're on hearing day, court staff has become involved, the judge has become involved and has set aside time for that hearing. So there is an impact. Maybe there are ways of improving that, but at least the mediation itself is done by third-party paid mediators, and at least some of the coordination is done through a different program within the court, so it's not impacting the same resources. So I think there is probably some room for improvement. And the other thing that we can try to figure out is, are there other ways that we can encourage the pre-litigation mediation process and expand that so that it never enters the court where we can avoid it?
Thank you. Other questions? Representative Chase?
Thank you. Thank you again. I just wanted to follow up with my question earlier about when the pilot program is going to end and what's the overlap going to be.
I have to get a better answer for that. I think it's through the year, but I'll find out from Margaret and send an email to the committee.
Other questions? Seeing none, thank you for your testimony today.
Thank you very much.
Representative Di Lorenzo, I see you put a card in. I see you're a co-sponsor. You've already sat as a member of the committee and asked a question, which typically you wouldn't do if you're going to speak. I guess, does anybody have an objection if Representative Di Lorenzo were to speak at this point? I see no objection, so but that should be a lesson for everybody, I think, in the future. You should not be, if you're going to speak on a bill, not be sitting on the committee and asking questions. Thank you.
Thank you, Mr. Chair, and I apologize to the committee for my little faux pas. I had thought that I could only not speak during executive session, but I was wrong. Okay.
Mr. Chair,
Right.
could you just clarify that it is an executive session that you can speak?
Right.
It's in the hearing
Oh, good.
that you can't.
Okay.
Go ahead.
Okay. Well, I just wanted to talk really briefly about my experience with mediation when I was a property manager, particularly in Suffolk County, Massachusetts, which would be Boston and Boston Housing Court. In the Boston Housing Court, mediation was offered to landlords and tenants, and the mediation happened after the case was filed, after it was entered into the system. On the day of the hearing, the judge would ask if folks wanted to talk with a housing specialist who was the mediator. And I did a lot of those cases for non-payment of rent. And typically what would happen is that, let's say a person owes, like, I don't know, $500 rent, and maybe it's a month and a half, 3 months rent. What would happen is that we would come up with a payment plan, and the landlord would sign it, the tenant would sign it, and once the payment agreement was fulfilled, the tenancy could be restored to full tenancy. But I found that it was really helpful. It was a conciliatory process rather than a punitive process, and so I just wanted to let folks know about that it worked out for me as a landlord. It was wonderful. Thank you.
Thank you. Are there questions for Representative Di Lorenzo? Representative Chase?
Thank you again. And thank you, Representative Di Lorenzo. I'm just curious with the payment plan. So were you in there as a landlord?
Yes.
And so you had to agree to the payment plan and keep this tenant there. If you chose not to, you could just have abolished that and terminated the tenancy?
Yes, that's correct.
Thank you.
Okay.
Other questions? Seeing none, thank you for your testimony today.
Thank you, Mr. Chair.
Is there anyone else who wishes to testify on Senate Bill 216? Seeing no one, we will close the hearing on Senate Bill 216. And our next hearing is scheduled for 10 o'clock. and we will be in recess until 10 o'clock. I'd note that I have to testify on a bill in another committee at 10 o'clock, and I will be turning the reins over to the vice chair, Representative McLean, to run that hearing.
Just one last question. That's fine. Especially after we've been school. So, and we'll. Well, good luck with the bridge net.
Well, thank you.
Do we have any other speakers, or is this the only card we have?
That's the only card we have currently. You're in charge.
I'll Yeah, so good morning. Representative Gordon had to step out to testify on another bill. So I'm going to step in for him and we're going to open the hearing on HB 297 and recognize Senator Carson to introduce the bill.
Good morning, Mr. Chairman, and again, members of the House Judiciary Committee. For the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration today Senate Bill 297, relative to obtaining out-of-state discovery and testimony. This bill allows testimony and discovery from a foreign jurisdiction needed for litigation pending in New Hampshire to be obtained without a court-appointed commissioner and pursuant to the procedure in the foreign jurisdiction. 43 states have already adopted this language and will simply remove an unnecessary step for our attorneys while maintaining appropriate procedures. At this point, I will conclude my testimony. There's someone here from the judicial branch who will be able to explain to you why we need this bill and everything else behind it. So thank you very much for your time this morning.
So as a co-sponsor on the bill, I won't be asking any questions, but does anybody else have any questions for the senator? Representative Chase.
Thank you. Thank you, Senator, for taking my question. And it may be for Attorney Head, but how often does this happen that something is blocked because you cannot get testimony from another state?
Thank you very much for your question. I completely agree with you. I think Mr. Head is going to be in a better position to answer this question than I am. Thank you.
Does anybody else have any questions? Thank you, Senator.
Thank you very much for your time this morning.
I don't have any other pink cards, but the senator did mention that Attorney Head was wanting to speak.
Desperately. Thank you, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I have a partly filled out pink card. I will complete the filling out of that pink card. Was not planning on testifying, but generally we would support, obviously, this Senator Carson's bill. The issue is very complicated because and so in my experience in private practice was if you need out-of-state testimony, there's a fairly complicated process currently in place. It is possible to do. You can get what's called a commissioner appointed. You have to go to the local court. You have to get an order from your local court. You then have to take that order, go to the foreign jurisdiction. So if it's in Ohio, I have to bring that to Ohio. I then have to do stuff according to Ohio law to get somebody in Ohio to get an order. You have to get an order in Ohio, probably usually. And then I have to get somebody to make service, and it's a fairly complicated process, and it takes a lot of time. And then I have to go to Ohio, I have to take the deposition and come back. There is a uniform act, and in fact, New Hampshire has partially passed the Uniform Act in that if somebody from another state who has passed the Uniform Act is trying to get discovery in New Hampshire, they can do that according to the Uniform Act. And basically it just says, go ahead and get your discovery as you would in New Hampshire, and you don't have to do anything special. It would allow a New Hampshire party to have that same benefit when traveling or when needing discovery from somebody out of state. And it simply provides New Hampshire lawyers and New Hampshire parties the same opportunities that currently folks in other states have when they're trying to seek discovery in New Hampshire. So it does make for a smoother process. It does also eliminate a step with seeking an order from a New Hampshire court. So benefit there for us. So overall, it just makes for a much smoother process. And it only applies where the other state has also adopted the Uniform Act. With that, be happy to conclude my testimony and answer any questions.
Are there any questions? Representative Chase.
I'm not a lawyer, so bear with me. All right, so this is for, is it for, say, if you wanted to get information from a company, or is it from a certain person? Is it something that maybe a crime that had happened here and then the person lives in a different state and you need to get their testimony? I'm just trying to figure, I understand it, but I want to see where it fits.
So it fits in a lot of different circumstances. So in the context of civil litigation, there are people who may have facts or may have documents who are not residing in New Hampshire. And a subpoena from a New Hampshire court has authority within the state of New Hampshire. So a New Hampshire judge cannot order somebody who lives in Ohio to appear. And that's where the rub occurs. We just have limited jurisdiction in our authority to issue subpoenas. So anytime there is somebody who has either physical evidence that's outside of New Hampshire or testimonial evidence that's outside of New Hampshire, the question is, how do you get that into New Hampshire and into the case that's in New Hampshire? We still can't physically make them come to New Hampshire, but it is an easier process. If it's testimony, we can take videotape testimony. If it's documentary, typically what is done is a party that holds a document, you would schedule a deposition, but say, if you get us the documents ahead of time, you don't need to appear, things like that. And it just makes for a much smoother process when you're dealing with multiple states.
Are there any other questions for anybody on the committee? That being said, thank you very much for your testimony.
Thank you. Thank you very much.
Is there anybody else that wishes to speak?
Yes, good morning.
So the committee recognizes Neil Nickerson?
Nicholson.
Nicholson.
Yes, thank you very much. Good morning, everyone. So nice to be here with you this morning. My name is Neil Nicholson. I am an attorney that practices here in Concord at the law firm, Nicholson Law Firm. I practice mostly civil litigation, and I am testifying in support of this bill. I am also the past president of the New Hampshire Association for Justice. I'll be very brief. I thought Attorney Head did a very nice job summarizing this bill, and I'm going to synchronize it maybe even a little bit further. The reason why we are in support of this bill is, number one, it improves judicial efficiency. So by passing this bill, we will no longer have the need to file a motion in a New Hampshire Superior Court in order to get approval to have another lawyer from another state act as a commissioner to take testimony or to otherwise gather evidence in that foreign state. So we will no longer have to, file a motion that's going to take time and resources away from the judicial staff and a judge in order to rule on that motion, which I will tell you most of the time are assented to motions. So there are situations where the attorneys on both sides agree that this process needs to go through. This is just kind of an antiquated process that we're still operating under here in New Hampshire. The second reason why testifying in support of this bill is that it will actually increase the speed by which people involved in litigation will be able to get access to evidence. So the case will proceed in a faster fashion, which is always a good thing, rather than having unnecessary delay, which is what we have to deal with under the current structure. Thirdly, and I would say most importantly, is by passing this bill, it's actually going to reduce costs and attorneys' fees for people that are involved in litigation. So no longer will a person who is a party in litigation have to pay for an attorney, me, to go to that state, wherever it is we're trying to find a witness or evidence, and find an attorney in that state who's licensed in that state who would be willing to act as the commissioner, and then spend time and money on me to file the motion in court, get it approved, hire the lawyer in the foreign jurisdiction in order to act as the commissioner. So it would actually end up saving litigants money in attorney's fees, which is, good for them and good for all of us. So those are the reasons why I support this bill. I'm happy to take any questions.
Does anybody in the committee have any questions for Mr. Nichols? Thank you very much for your testimony.
Thank you so much.
I don't have any other pink cards. Is there anybody else who wishes to speak on this bill? All right. With that being said, I'll close the hearing on SB 297.
Okay, we'll call the House Judiciary Committee back to order. Our next item of business this morning is a hearing on Senate Bill 301. That is relative to the procedure for violations under the right to know law. The primary sponsor of this bill is Senator French. And Senator French, would you like to introduce the bill?
I would, thank you.
Good morning, Mr. Chair and entire committee. It's good to be here today. For the record, my name is Harold French. I am Senator for District 7, and I'm here to introduce my Senate Bill 301 FN. In brief, this is relative to the procedure for violations under the right to know law. This bill is designed to give clarity to the plaintiff on what to do if they are denied their request under 91A. And it gives guidance to Superior Court on how to handle it. And in brief, that's what it's all about. So there are people behind me, I think, that will be testifying and telling you the intricacies of it.
Are there questions for Senator French?
Perfect. Thank you very
Seeing
much.
none, thank you.
I'll remember that if you come to testify before us.
Thank you very much. Thank you. The next speaker is Margaret Burns.
Am
You
I
are
on now? Okay. Good morning. I'm Margaret Burns. I'm the Executive Director of the New Hampshire Municipal Association. We do not have a position on Senate Bill 301. We worked with the Senate Judiciary Committee to make some changes to the original version of the bill, just to clarify a few things. I have just one very small comment on the current version of the bill, and that is in line 3 as well as in line 6. The bill refers to government records or information requests. And then in line 6, talks about the production of government records or information. My very small comment is just that under RSA 91, section 1A, the definition section, records are information is a sub definition of government records. So it is really unnecessary to state both pieces, because government records will contain information and all other documentation in an ascertainable format. It's sort of a all-encompassing definition. So that is one very small comment for the committee's consideration. I have no other comments, but I'm happy to try to take any questions if there are any.
Questions for Ms. Burns? Yes, Representative Chase.
Thank you, and thank you for taking my question. Would you just make it clear to me, what are you saying? Take out government records or information?
Take out
Which one?
information would be
Information
my-
and leave the government records.
That's
Thank you.
correct. Thank you.
Representative Smith.
Thank you, Mr. Chair. Can you tell me why you are not taking a position on this?
Absolutely. The way that we read the bill, it's putting sort of guardrails and parameters around the process. And in doing so, it probably will benefit both plaintiffs and governmental entities that are involved in lawsuits related to governmental record issues. I spoke with some municipal attorneys as well to sort of get their input and see if I was reading that correctly. And they agreed that having parameters around the process could actually benefit both sides.
And therefore,
Follow-up?
thank you, I'm sorry.
No problem.
So can you tell me why you are not taking a position? Why you are not supporting this?
We're neutral on it because it doesn't specifically fall under any of our member adopted policies. It doesn't create new authority. It doesn't erode current local authority or specifically fall under any of our member adopted policies. And in those circumstances, we are generally neutral on bills when that is the case.
Thank you. This is not the time to follow up on that.
Other questions? Seeing none, thank you for your
you.
testimony today. Lori Ortolano.
Good morning, Lori Ortolano, Nashua. I'm representing Right to Know New Hampshire. I spoke to this bill when it was introduced over in the Senate, and Right to Know New Hampshire took a position against this bill. At the time, the way the language was written, it included submitting all responsive documents that were provided to the respondent. And in some instances, there's a lot of documentation given that did not need to be included in a lawsuit. For example, I had a request for information that I thought looks like it's been amended and some of the language has been changed. Our group took a position against this because we were more interested and strongly supported the ombudsman bill that is moved out of the House and is over at the Senate and has been a work in progress for 4 or 5 years. We felt that that position and the handling of right to knows in that manner was sort of where we put our eggs into that basket. This change in the language, you know, one of the concerns Right to Know New Hampshire had is it really doesn't address it. It addresses records issues, but not meetings. RSA covers two types of 91A covers two types of issues: document requests that are not satisfied and meetings that are not held correctly. And so this language seemed to speak to the document issue and not really the meetings issue. So we didn't believe it was complete enough. And honestly, I believe this legislation was drawn up because of things that were happening down in Nashua in my city. There was, you know, some folks that wanted to try and assist with what was going on down there. But I'm always hesitant to create legislation because of maybe the bad practices of one municipality and transfer that through legislation that has to apply to the whole state. So I'm really cautious about doing that and making certain when we do that, we're getting what we want. So that's been our concern with it. I just heard the lady before mention that they would strike information for the production of governmental records or information because a lawsuit filed under 91A would be a governmental records suit. But there is an informational component to it that I, like to call out just for awareness. When there are exemptions applied and you're denied records under exemptions, the municipality is supposed to provide a brief explanation of how that exemption applies. And so that would be sort of an information response that could prompt a lawsuit. And in fact, it's been a problem, I know, in my municipality where exemptions are given, but an explanation for that exemption or how it applies is not given. And that has drawn me to court to try and figure out why documents are not provided. So that isn't necessarily a records issue. It's an exemption issue with a lack of information provided and clarity. So in that sense, information could be included when there's exemption challenges coming forward. So, I guess our position would be that maybe there's a little more work in progress to go on here. And the other thing that was discovered, I think the courts right now are really struggling with right to know issues. The pandemic had an impact. The priority nature of getting your right to knows through because they're supposed to be priority matters has not really happened because the courts are backlogged. So understandably so. But the other thing that's been going on is that I found there was an administrative order passed in 2013 called AO 213-08, which calls out exemptions to certain types of civil matters to be exempt from trial rules. And right to know falls in that category. It is exempt from trial rules. And there's a list of rules that don't apply, like answers to a lawsuit don't apply, interrogatories, discovery, That doesn't apply. The judge can order it to apply, but ordinarily a right to know case would be heard on a merits hearing. And I think the courts, to some extent, some of them have forgotten that. They're pushing a lot of these right to know challenges to full blown lawsuits, and they don't need to be. It happened to me. I just finished 2 pro se cases. They were full blown lawsuits. I mean, they were full blown trials, discovery, depositions, everything. And they could have been a merit hearing, which would have been much cheaper and less time for everyone to go through. The reason I took them on myself is because I knew they were going to, each one would have cost me $25,000 to go into court. And I didn't want to spend that. I won the first one, 99% certain I won the second one. So I'm feeling pretty good about where I stand on those. But it was a lot of work. It was very stressful. It's incredibly difficult. So I think trying to make the courts and help the courts understand and refresh their memories on Administrative Order 213-08 is important, so that we can try and keep these things as merit hearings, minimize the impact on the court, the fees to the filer, and you know, so that's sort of where I stand.
Questions? Representative McLean.
Thank you, Mr. Chair, and thank you for taking my question. So is it right to know's position then that they think that the structure put forth in this bill is too restrictive, maybe pushing people into a trial when it could be a merit hearing, and that maybe the ombudsman is just the better approach to allow more flexibility? I'm just trying to get a feel for where you're thinking of going.
Yes, I think that's a fair assessment. We do think the ombudsman is where we'd like to, focus our energies and our time in that area, and auditing that should it take place, and making certain it's working the way we want it to work and modifying it. So that is definitely where we want to go. And we do feel this is restrictive because it doesn't pick up meetings. And we think that reminding the courts of when they go into Superior Court to be heard as a civil matter, to try and focus them as merit hearings and not full trials.
Representative McLean, you can follow up.
Thank you, Mr. Chair. And just a quick follow-up. So then, even if we were to amend this legislation to incorporate meetings, your position would still be one of wanting to go the ombudsman route?
Yes.
Thank you.
Yeah.
Other questions? Thank you, Representative McLean, for asking mine. So,
thank you.
Thank you, Ms. Ortolano. Is there anyone else who would like to testify on Senate Bill 301? Seeing no one, we will declare the hearing closed. Thank you very much. And our next item of business isn't scheduled until 11. So we will be in recess until 11 o'clock. I thought we would be running a tight schedule today. Because that means that someone's coming in. Okay, it being 11 o'clock, we'll move on to our next item of business. We'll reconvene the House Judiciary Committee. Our next hearing is Senate Bill 222, permitting licensing boards to conduct remote hearings. And we'll call upon the prime sponsor, Representative Khan, to introduce the bill.
Thank you very much, Mr. Chairman. For the record, I'm Jay Khan, State Senator from Keene, representing 15 of 23 towns in Cheshire County. And it's a pleasure to be before the House Judiciary Committee. I'm usually on the receiving end, being on the Senate Judiciary Committee, so this is a pleasure to see and put the faces and names together. Thank you. This bill is relative to the licensing boards of the Office of Professional Licensure and Certification. And we know that there are the 54 licensing boards that they provide administrative support for. I began this conversation with Director Lindsay Courtney because over the summer of 21, there were experiencing slowdown in some licensing professions, and we entered a conversation, how can we accelerate this pipeline problem? And she described to me that they were having difficulty achieving a quorum for some of the licensing boards. Hopefully we are getting out of a pandemic and we don't face this, but as much. But the fact still remains, we want to have as diverse a representation on our licensing boards as possible. And diversity in our state often is defined by regional diversity across our state. Often licensing boards have 90-minute meetings and people are driving 2 to 3 hours to those meetings and then returning home in the same amount of time for a 90-minute meeting. And when we're talking about folks that are reimbursed per client, we're digging into the earnings of people that we're asking to be active in their profession and to serve the profession on these licensing boards. So that's what this bill is aimed to do. It is very specific to as to where it's placed. It's placed in RSA 310 so that it doesn't need to be put into every one of the licensing professions, but that it would allow each of the commissions to establish rules that would allow it to hold meetings electronically and providing alternative communication opportunities for members of their commission. And that's the nature of the bill. I believe there's somebody here from OPLC to speak to this. Thank you. And they can give you more details about which commissions they've had the difficulties with over the last year.
Questions for Senator Khan? Representative Horgan.
Well, maybe he'll defer this for when the representative OPLC comes, but what exactly happens at these 90-minute meetings? What do they typically discuss?
They will review licensing candidates, but they also will review people who have licenses and have disciplinary questions about those licenses. They also modify their standards for licensing and rules that need to be established after the enabling legislation.
Follow up?
Is this, so with these meetings, is it fair to say typically have a large percentage of the time spent in executive session if they're discussing specific candidates, or? Or
Sometimes they do.
yes,
Yeah.
thanks.
Yeah, and I say this when I was doing legislation on Medicaid to schools or telehealth. I joined the director of the department to meet with some of the commissions that would be affected by that legislation. So that's my insight. I haven't tried to attend the 54 meetings.
Other questions? I guess if I had a question, we've gotten a number of bills having to do with remote meetings over the last year or two, and it doesn't seem like we had this type of issue prior to the COVID issues. So I guess the question I have is do you view this as a COVID related problem, or if it isn't a COVID related problem, why is it now a problem when it didn't seem to be a problem in the past?
I think it's a great question to ask. I think this has been a problem in the past because of the distance factor and the professional time lost. Certainly the pandemic has been more trying for people to want to be at in-person meetings, but I think that this has been a problem in the past. And the question is, can we keep active licensed professionals on boards when there's this significant time trade-off to the business that they have to do?
Other questions? Seeing none, thank you, Senator.
Thank you.
I'm not sure how well I'm going to do this, but is it Jessica Kalapolidis? Oh, good.
So good morning. My name is Jessica Kalapolidis. I am the Director for the Division of Enforcement at the Office of Professional Licensure and Certification, and I am here on behalf of OPLC this morning. Just very briefly, OPLC does not take a position on this proposed legislation. However, the agency would note that there are a number of boards that we support that have been having physical quorum issues, as Senator Khan had indicated, since they've had to come back in person since the emergency orders ended, allowing them remote participation. Executive Director Lindsay Courtney also provided a letter which included a Excel spreadsheet which indicated which boards are having issues and to what extent. So I would point that out to the committee if you have not seen that yet. I think that provides a great deal of information that you might find helpful. Thank you.
Questions? Again, if I could just say, and I sit on a board, and when I accepted the appointment to be on that board, I accepted it with the understanding that I had to go to a monthly meeting. Why wouldn't that be an ordinary expectation for someone sitting on a board, that a requirement of being on the board is you're going to attend a meeting?
That's an excellent question. I don't have a great answer I haven't pulled all of the different boards that are having issues. I have heard from one subcommittee of a board in particular that is in the medical field, and those folks, some of them are still treating COVID patients. So they have concerns about potentially being exposed and bringing that exposure to a meeting in person, or they themselves may not be treating patients, but have some type of autoimmune disorder, or a family member does, and they are concerned about being exposed. So to some extent, COVID is still an issue for those folks, but I don't know that that applies to all the boards having this issue. And I don't know why perhaps it was not an issue in the past and is a larger issue now.
Other questions? Thank you for coming today.
Absolutely. Thank you.
And we have Lori Ortolano.
Lori Ortolano, 41 Berkeley Street. I'm representing Right to Know New Hampshire. Our position on these bills looking to create remote meetings for boards has been to oppose them, primarily because we feel a physical location is very important for any of these appointed or elected boards. We would be supportive of relaxing the quorum requirement or revisiting the quorum requirement, particularly for boards that have struggled. I don't have the data. My question was going to be, what is, let's look at the data. The OPLC has 53 different boards, and there's one that's on the table to be added that I'm interested in, which is moving the certification of assessors and discipline over to the OPLC. That's a bill right now moving forward. So, it would be nice to see how many of those boards had a quorum issue. And if we need to make an accommodation with that quorum for those boards, then perhaps that should be looked at first. I really feel a physical location is very important. I'm particularly concerned if the only means of dial-in is through a telephone versus Zoom. I think the being able to physically see people and have a physical location where you can address people, talk to them before or after a meeting, express any other concerns you might have if there is no public participation is really very important and very valuable. And I hate to see that given up. My sense was pre-pandemic that a lot of this wasn't nearly the issue it was over the last 2 years, and that we're putting this behind us now, and we should try to establish business as usual as much as we possibly can. So we would like to see a physical location maintained for these meetings and have our representative people available to us where we can go. And the other thing is, with a physical location, if different boards through OPLC are centered at having people perhaps come to Concord, there might be a better chance that if the quorum's relaxed, you would have a Zoom feed, a video feed where anyone attending would be able to see their appointed or elected representatives performing their duties. Thank you.
Questions for Ms. Ortolano? Are you familiar with OPLC at all and what they do?
Yes, because I helped create the bill to move the certification of assessors and discipline of assessors out from the DRA over to the OPLC last year. And so I became more familiar with their work and their boards that are set up. And we're looking now to set up a 7-person board to have certification and discipline handled through OPLC. So we would be an additional one moving it to like 55 groups, and there's a fee structure nominal to be within that organization. And so I have some familiar, they came in, OPLC, a representative came in and presented to the Assessing Standards Board about their organization, what they could do if they took this on. And that's why our subgroup of certification moved forward with this legislation through that agency.
The reason I asked the question is trying to figure out what role OPLC plays in this, if any, in the attendance at board meetings. And because it seems like we have OPLC now with a much greater formality in the way the boards are managed and handled, as opposed to prior to OPLC, and where we didn't necessarily hear about the problems that we're hearing about now with regard to attendance. I was just wondering, and then this is a question probably better directed at Ms. Kalapolidis, and that is, do you think that this OPLC and the formalities of OPLC and the more requirements created by OPLC might have some role in people's unwillingness to attend?
I'm not necessarily certain of that. I look at the Assessing Standard Board as an organization, and they take in, they're a 13-member board or 16, some directly from the DRA. They meet in Concord, but they have representation from all over the state, assessors or select person managers come in from all over to come to these meetings. So it's a commitment and it's a challenge to come, but they always meet monthly, and there is audience attendance. There's usually 4 or 5 people that show up, other assessors, other locations that come speak. They have a public comment, participate, and give general information as they're discussing topics. And I think if you took that group and you said, hey, we'll just go remote with telephonic meetings, it would be an entirely different meeting format. And I think what you'd get from the meeting would be not as helpful. Yep.
Thank you.
Yep. Thank you.
Other questions? Yeah. Yes.
Came in our email.
Yes, you're the only one. Is there anyone else who wishes to testify on Senate Bill 222? Seeing no one, we will close the hearing on Senate Bill 222. And we will be in recess. Our next hearing is at 1 o'clock. Thank you, everyone.
Yeah, you want to do that or would?
Okay, we'll call the House Judiciary Committee back to order. And our next item of business today is a hearing. It's a hearing on Senate Bill 392, establishing a commission to study insanity and restoration of competency. The primary sponsor of this bill is Senator Sherman, and I see that he's here. Senator Sherman, would you like to introduce your bill?
Thank you, Mr. Chair. And for the record, my name is Senator Tom Sherman, District 24, representing 11 towns on the Seacoast. And I'm introducing Senate Bill 392, which has had an interesting journey. It's establishing a commission to study insanity and restoration of competency. As a little bit of background, I serve and actually, Representative Cushing was on this commission, on this council. It's the Governor's Advisory Council on Mental Health in the Corrections System. And one of the areas that we identified as a council of concern is restoration. And there are people far more qualified than me to explain restoration. But it's really critically important to protecting both the accused and the victim, that people who have been declared insane go through a process of restoration so they can actually stand trial for their crime. So that's one part of this, and I will leave it to those who are far better than me to explain that. The original bill simply redefined insane and was a request of the Department of Health and Human Services. The state statute on insanity has not been amended since 1918. So it currently reads, this is amazing, open quote, "The words insane or insane person shall include every idiot, non-compos, that's C-O-M-P-O-S, lunatic, insane, or distracted person," close quote. That's our current definition of insanity in statute. And, you know, distracted person, I think that'd catch all of us, certainly out on the roads these days. So clearly it does need revision, but when we actually revised it and it was going to hearing on the Senate side, the DOJ, the Department of Justice, said, wait, stop. This will absolutely affect cases that are currently in court. So that's why we went to the idea of a commission. And because the two issues are so closely related, we brought in the issue from the Governor's Advisory Council as well. Recognizing that there is a concern about more commissions, especially on this side of the wall. I have 2 amendments and potentially 3, depending on the will of this committee, that would turn this into an executive branch administrative working group. That's a mouthful, but we have done this really successfully with the Medicaid dental benefit. That was probably the best recent example of figuring out what the best answer is, bringing all the stakeholders together without having to have it in a commission format. They're very effective, nimble, and as nimble as you can be with 17 different members, but it really would be a viable alternative to commissions to answer these 2 questions in a way that did not impact current court cases and also really benefited the state. So the main difference between these 2 amendments, all they're doing is taking the bill, the commission format, turning it into an executive branch administrative working group. And the only difference between the potentially, actually, I guess there could be 4 amendments, is the number of people participating on the House side. In the original bill, there were 3, and you know, it's completely up to you whether you want 0, 1, 2, or 3. But these 2 amendments are in the form of 3 House, which would be the same as the current bill, or 0 House members, and certainly all you'd have to do is insert a 1 if you want 1 House. We would like to keep our membership on the working group from the Senate side. So with that, I can hand these out and answer any questions you might have.
Questions for the senator? Would it be okay if we put 4 senators on the committee?
That'll get a committee of conference.
Could be. Any other questions for the senator?
I can leave these with you to
That would be
be
great.
passed out.
That
Thank
would-
you very
that would be
much
helpful.
for considering this.
Thank you. We have, actually, I understand that there are 3 physicians who are here who would be testifying together. Dr. Samantha Sweater, Dr. Andrea Mouchet, and Dr. Daniel Lampanano. If that's close. Hey, why don't you come on up?
Is it, do I have to press that?
No, you're on.
Okay.
Welcome to the Judiciary Committee.
Oh, thank you. Good afternoon, my colleagues here, Dr. Lampagnano, so very close, Dr. Samantha Sweater. I'm Dr. Andrea Machette. I'm actually a licensed psychologist and the director of the forensic program at New Hampshire Hospital. As you heard from the senator before about the definition of insane and how it obviously needs to be changed and updated. And we also, with the construction of the new forensic hospital and how this is like the best time to review the current sanity, competency, and restoration needs of New Hampshire to make sure that they align with the national practice standards. This executive work group seeks to investigate this with collaboration with our partners from DOC, DOJ, as well as our community stakeholders to establish an executive work group. This large collaboration will allow all the voices of the stakeholders to have a seat at the table to discuss the needs of New Hampshire and our clients of the community. And we didn't know if you had any specific questions or clinical questions that we could help answer.
Are there questions? Yes, Representative Chase.
Thank you, and thank you for taking my question. So in other states, do we have a sample of what the definition is? Like, I don't even want to say it because it's all so bad. Sorry, but is that what we're just trying to comply and really bring things up? I mean, it's, I know I had read that before for something else and was just appalled that it also that it had been from the 1800s and nothing had ever been changed. So are there examples, or is that what you're trying to do, is just get the wording correct and be able to establish what we know now from what we knew in the 1800s?
There are many examples across the country with more updated language that's a little bit more respectful and preserves the dignity of folks who have been diagnosed with mental health disorders in the context of their involvement with the justice system. And that would be part of the working group's scope, is to kind of revisit some of those other definitions and see what makes sense for New Hampshire.
Other questions? Representative Di Lorenzo.
Thank you, Mr. Chair, and thank you for taking my questions. I know that some things have changed over the years as far as mental health is concerned, and I believe that alcohol misuse disorder and drug misuse disorder have been called disabilities. So I'm wondering if any of the diseases related to alcohol misuse and drug misuse, have those entered the realm of insanity at all?
That's an excellent question, and something that's been struggled with over the past many decades, as long as we've been defining insanity legally. That's something that generally has been, or often been, excluded from the definition of insanity. But again, that's something that this working group would be coming together to wrestle with.
Other questions? Yes, Representative Nodder.
Thank you, and thank you for taking the question. I don't understand why we need a whole commission to just change a definition. Can't we just change it?
It's another excellent question. This started out as something that was very simple, which was to address a definition. And what came out of this process very quickly as we were collaborating with our other partners in Department of Justice in particular, but also the Department of Corrections, was that changing a simple definition is going to have ramifications elsewhere within the systems. And that this also might represent an opportunity to visit other forensic issues and try to improve those systems across the board. And that's why this working group has been proposed.
Other questions? Representative Macbeth.
Thank you, Mr. Chair, and thank you so much for taking my question. I'm wondering, is like situational insanity versus maybe longer term condition, would that be investigated or looked at by this commission? And I'm thinking maybe of somebody also that maybe be unmedicated versus medicated, or in some type of trauma or crisis versus someone.
It's a difficult question
Yeah.
that we're struggling with. I think that what we could say is that all these various scenarios, that's why it's important to have a working group, so that different voices and perspectives can bring various scenarios to the table so that we're looking at all angles.
Thank you very much. Thank you, Mr. Chairman. No further questions.
Representative Nodder.
I hate to ask this. Ask you to say some ugly words, but I don't see it in here. Could you define the current word? What is the current definition for insanity?
For insanity, for insane, it is, quote, shall include every idiot, non-compos, lunatic, insane, or distracted person. Is the current.
Isn't that all of us at one time or another?
Yes.
Your Chair.
Representative Smith.
Thank you, Mr. Chairman. As I understand it, there are two parts to this. The first part, and tell me where I'm wrong, because I'm sure I'm wrong. The first part is the definition of insanity. The second part, whatever that definition ends up being, is how you would use that definition to evaluate whether someone theoretically who has been receiving treatment has moved past the definition of insanity to a point when they could be considered competent to stand trial. Is that close at all to what you're talking about here?
Not exactly. It's a great question. So in order to be deemed insane, you have to be deemed competent first. So the goal is initially, which Dr. Bader can also testify to, is if there's alleged charges, you work with your attorney, and the attorney sees that there's a need for competency because the person does not seem mentally stable at the time. So a competency evaluation will be done. And if they are unstable at the time, they will be deemed incompetent to stand trial for a period of 12 months. For it's a restoration period in the state of New Hampshire is 12 months. And then after that 12 months, then they have an evaluation again to see if they were able to gain competency or competence, if they received treatment and whatnot. If they have not, then they are deemed incompetent, not restorable. And usually what we've seen is then cases are dropped or null prossed. However, if they are deemed competent, then they are able to then face their charges and either plead guilty, not guilty by reason of insanity, or no contest.
And could I follow up? Thank you. I guess I don't understand why, whether or not the state builds a new forensic hospital, should play any role in this legislation. If we are suffering with an inappropriate aged definition of insanity, and if we want to figure out how we manage competency, the existence of the forensic hospital or not is irrelevant to me. Am I missing something?
No, ma'am. The goal is to parallel the process with the hospital becoming available soon, soon in the next couple of years soon, and to be able to use that to streamline treatment for incompetent individuals and to accelerate their treatment.
Thank you. If I could just...
Please.
Thank you. I was under the impression, and you know so much more about this than I do, that all that the state has talked about so far is a facility. There's been no talk about staffing the facility, about equipping the facility, about programs for the facility. And so I am concerned that if in the fullness of time a facility doesn't come online, would not you still want to make these changes?
Let me know if I misunderstood your question at any point. The importance of this working group is to ensure that the new forensic hospital is as functional as possible in meeting its mission. On the books currently, there are certain statutes that dictate that these individuals of various legal statuses, NGRI, sometimes incompetent to stand trial, will be treated at the state prison under the secure psychiatric unit. So it is important that if we're going to use the new facility in order to treat these individuals, that these statutes be updated. And that would be part of this working group's scope, is to examine all of the aspects of or processes under which these forensic patients find themselves and ensure that the forensic hospital is functional from a statutory standpoint, which can then be also translated into staffing, programming, and what have you. Does that answer your question?
Would you permit me just one more?
Certainly.
Thank you very much. Are you saying that if there was not a plan for a new forensic hospital, you would be content with the current definition of insanity and the current law as to competency?
No, ma'am. That's not what I'm saying.
Thank you.
Yes, ma'am.
Representative McLean.
Thank you, Mr. Chair, and thank you for taking my question. So just to clarify, whether or not a forensic hospital were to be built, the goal of this is to kind of look at where are the national practice standards and to bring our statutory law into alignment with those national practice standards, whether or not a forensic hospital were to be built. Is that correct understanding?
100% correct.
I'm glad you solved that. Representative Macbeth, did you have a question?
Thank you. So, thank you so much, Mr. Chairman, and thank you for entertaining this question, because I feel like Representative Notter's question rung with me. But then I read, and I'm, so frequently we think of insanity and restoration of competency in the criminal aspect, but I see in the very first statement of the bill, this is also civil and probate court matters. So this is going to impact, guardianships, correct, and involuntary committals, people that are outside of the criminal context. Is that correct?
It's not going to affect civil committees who are not justice involved.
Sorry, could you say that again? I didn't hear you.
Sorry. If somebody is already on a civil commitment and just say the civil commitment will stay with them unless somehow they become justice involved, and then it would be a hybrid of the systems working together to figure out and compromising on the best treatment and care depending on the situation.
Follow, Mr. Chair. Is
Yes,
there
go
a
ahead,
structure
please.
for the collaboration between probate court and civil court already, or does that require rulemaking as far as somebody that may be under a guardianship or involuntary commit? Both of those are separate.
I'm going to give this a shot. Currently, there are statutory requirements as to whether somebody is seen in probate court or superior court, and we don't anticipate that this working group is going to be trying to change that. I think it's everything downstream of that, what happens after they've been adjudicated in superior court or appeared before probate court. Does that answer your question?
So thank you, and you've answered it better, but I'm just the example of somebody that is under a guardianship after they've already committed a criminal act.
Right.
So then this might impact them, or no, because they may be determined insane and the criminal charge maybe, or there's some, you said the hybrid. I'm not familiar with that hybrid collaboration. Is that in rules, or is that just something that happens?
I'm running the risk of saying too much before we actually form the working group and work some of this stuff out. But what I would say is that we don't anticipate that guardianship is going to be, the function or process by which guardianship is determined would be altered by this process, by these questions. Yeah.
So if I could just follow up one.
Yep. One last follow-up.
I'm hoping that you do consider, though, people that may have been criminally charged prior to the granting of a guardianship and have, so maybe I need to be part, no, I'm not at, so I didn't really, I appreciate your question because I wasn't asking for a change in the guardianship process. I'm just concerned that this definition may impact people under guardianship that have been criminally charged. Thank you.
Other questions? Yes. Representative Langley.
Thank you, Mr. Chair, and thank you for taking my question. I would agree with you that the original definition that goes back to the 1700s is abominable, and really we should be embarrassed that we still have it on the books. That being said, I'm not clear as to how we're going to redefine it and also integrate it with the DSM, because a lot of work has been done in terms of diagnostic work over the years. So it's hard for me as I look at this law to see how we're going to integrate that work with a more succinct definition of solely insanity. Can you help me understand that better?
Yes, I think so. Fortunately, we have many roadmaps that other states have already trodden in trying to balance this fidelity that we want to show the DSM in defining mental illness and the legal definition of insanity and how that's applied within the legal system. There have been trends amongst the states that use one of only a couple of standards. And so I anticipate that part of the work of this working group would be to look at these standards that have been established over decades, have been vetted through many, many, many years of case law as well, and determine what makes sense for New Hampshire.
Thank you. Other questions? Representative Lorenzo.
Thank you, Mr. Chairman, and thank you for taking my question. As we were talking about insanity and the grounds for insanity, I thought about the McNaughton rule, which is based in common law. How is that applied these days, and would it have any relevance to this bill? Thank you.
Thank you for your question. The McNaughton standard that you reference, among those states that do offer an insanity defense, this is the most commonly applied standard. And so while it does have a basis, a tradition in common law, it has been statutorily ratified in a number of jurisdictions. It is no doubt, should this working group be approved and formed, it would be considered as part of that scope of work.
Thank you.
Other questions? If I could just, so you're dealing with the definition of insanity, and I understand that's part of the intent is to come up with a new definition, but you're also dealing, it seems like the focus seems to be on the court process and competency. And my understanding is that the standard for evaluating competency is different than insanity. It's not insanity. So is it your intent to meld the two, or are we dealing with two different subjects?
Those subjects would be dealt with individually.
Okay. The second question I have is with regard to the structure of this working group, because it seems to be large and I'm not sure how wieldy it is, and I'm not sure any legislators want to be on it, but that's another whole issue. Yeah. I might assign Representative Wolper. So long and the short is, it seems to me that you've appeared here today, and we really appreciate you being here today because you have expertise. Trying to figure out what expertise some of the other people who have been named to this commission are going to add to defining insanity, or even addressing the issue of competency and restoration of competency. I'm trying to think in terms of structuring the way that this should be addressed. I'm just wondering if it would not be better to authorize the Department of Health and Services to come up with a recommendation and direct that they consult with these individual groups. In doing so, to be a far more efficient process than trying to create a commission, which we've heard several times here today you can't get a quorum for. So that's another whole issue. So I'm just wondering if that might be a different approach or a better approach.
What I would offer is that although the Department of Health and Human Services interacts with individuals who have been deemed not guilty by reason of insanity, who are charged with attempting to treat and therefore restore the competency of those who are deemed unfit to stand trial, currently the Department of Health and Human Services does not make those determinations. Those are made by the Office of Forensic, or with the aid of the Office of Forensic Examiners under the Department of Corrections. So you can see that already, just on the face of it, we have already 2 departments who are very involved in this. We think that what we have proposed, or that what has been proposed, is a good attempt to bring together all the stakeholders who have various degrees of expertise in all of these issues. The ramifications aren't just going to be perfectly understood by the Department of Health and Human Services, and while we could consult the Department of Justice or the Department of Corrections, truly within their realms in a way that it impacts the work that they do and the citizenry of New Hampshire, they are the experts within their own niche. And I think it's important to bring them in a much more formalized way.
Other questions? Seeing none? Thank you for your testimony. Thanks for coming today.
Thank you.
Holly Stevens.
Chairman Gordon and members of the committee, my name is Holly Stevens, and I am the Public Policy Director of NAMI, New Hampshire, here today to speak in support of Senate Bill 392. Did want to take the opportunity to thank the sponsors for being one of the named entities on this commission. I do understand that there are some amendments to change it from a legislative commission to some other working group under the executive branch, which we would not have an opinion on one way or the other. Want to thank the committee for being able to testify today. As you've heard, there's currently not a restoration process in the state of New Hampshire, and I'm going to speak to the restoration portion and the competency portion of this, and not the insanity portion of this bill, because they are separate and distinct. But currently there's no restoration process, and at NAMI, New Hampshire, we have heard from families of their loved ones who have become justice involved that they see this as a missed opportunity. One would think that everybody involved, the families of these folks, would be happy that after a year, competency hasn't been restored and the charges are dropped. But what they really see is that that's a missed opportunity for their loved one to be able to have treatment. What the families have seen is that their loved ones go on to potentially become homeless, commit other crimes, commit more serious crimes, or have other unfortunate life outcomes. And there are mental health courts within the state of New Hampshire, but these folks, and I'm sure the AG's office and other lawyers behind me will also let you know that the mental health courts aren't an option, because you have to be able to give informed consent and you have to understand the judicial process. And those are, folks that are deemed incompetent can't give informed consent and do not have the ability to understand the judicial process at the time. So therefore, that would not be an option for them. And so this commission would allow for the state to look at all the options that are out there and maybe even get creative and do what New Hampshire does best, which is come up with New Hampshire solutions. And I know, Chairman Gordon, you're concerned about the unwieldy size of this. And I just wanted to let you know that, from NAMI New Hampshire's perspective, we do talk with these families and we work with these folks. And I think that we can bring a perspective to a commission that we might be able to come up with some creative solutions with the defense bar and with the AG's office and with the Department of Corrections and the Department of Human Services so that these folks are able to receive the treatment that they need. And if they are restored, that maybe there can be some other alternatives for these folks other than simply incarceration. That, given their mental health status at the time that they committed the crime, that maybe we can come up with some other alternatives, such as the mental health court system, once folks are restored. So I would urge this committee to seriously consider voting this through as either a working group or a commission. We are in support of this, and I will answer any questions that you may have.
Are there any questions, Ms. Stevens? Seeing none, thank you for your testimony.
Thank you very much.
Jeff Strelson. Please. Come on up.
Thank you very much. Hi, good afternoon. My name is Jeff Strelson. I'm an Associate Attorney General at the New Hampshire Attorney General's Office and a prosecutor about 25 years now, and have spent, unfortunately, a lot of time dealing with competency and insanity issues in the criminal justice system. We are in support of this bill. The reason I want to come up is to be able to answer any questions that any of you might have after listening to some of the questions I've heard before about how those two things work in the criminal justice system and why we had a concern about just changing the definition of criminal insanity and what that would mean. And Dr. Bader can introduce herself.
My name is Dr. Bader. I'm a board certified forensic psychologist. I'm also the chief forensic evaluator for the state of New Hampshire. So my office isn't responsible for doing all of the evaluations for competency and sanity throughout the state. And I want to give a little background about both of those legal terms since we've been talking about them a lot. The first thing to know is that individuals with severe psychiatric illness or intellectual deficits usually need end up often needing two different extra hearings when they get arrested. The first one is a competency to stand trial evaluation and then a hearing. This is really that requirement by our Constitution that folks are aware and understanding of their rights and what's happening at court. It's kind of a hidden process in our state. A lot of folks don't even know that competency evaluations happen or that this process exists, but it's necessary and it's required. And so if someone is not well enough to be part of their case, then they're deemed not competent to stand trial, and then we give a year for that person to get better. Now, what's important is that our state is the only state in the entire country that does not have a formalized process for folks to actually get better. So the court determines that this person is not well enough psychiatrically to actually be part of their case. They're expected to independently then go navigate Medicaid, make their own appointments, arrange transportation, and get well on their own. I can tell you from experience that that does not happen. And our numbers show that. Most states show 80% of folks become restored in their restoration period. In New Hampshire, our rates are below 40%. This is terrible. And I will also say the folks who are restored have a couple of things that have happened. One, their family members are involved. Maybe they've been part of this legal process with them and they are now, they found them, they were homeless, now they know where they are and they help. Or two, they leave the state. They go to Massachusetts or they go to New York and they're hospitalized in New York or Massachusetts and then come back. Those are the folks that are restored. Our process isn't broken, it doesn't exist. So as I said, 40% of our folks are restored. That means that 60% of those defendants have their cases dropped. Those cases disappear. Those victims get no day in court. They get no chance to have their case resolved. That defendant has no chance to have their day in court. They have no chance for the court to prove charges against them. In my experience, attorneys, lawyers, psychologists, people working at New Hampshire Hospital and NAMI, we rarely agree about details. We rarely agree about big pictures. We all have very different views. All of us agree that the system is broken and it needs to be fixed and repaired. And I want to address what someone said earlier about Why do we need a commission? I've been here for 6 years, and I will tell you that there have been actual earnest, driven attempts to fix this process. There have been these meetings between DHHS, DOC, the AG's office. We've had working groups. We've had judicial working groups. There are county level groups. I have a meeting on Friday at our quarterly Merrimack meeting. Hillsborough has been very active. We are unable to get to the actual changes we need because most people aren't able to all be there at the same time. As we've heard, we need both New Hampshire Hospital, Department of Corrections, the AG's office, all of those folks, but we need the judges on board. And then we'll have a meeting and we realize we need the New Hampshire mental health system on board. They're not at the meeting. This is the first time we've developed a working group that may feel unwieldy, but actually has every person that we need at the table. It also requires us to have deadlines and a structure that has been lacking. We have gotten together all the time and we talk and we talk and we talk and we talk and we all say, oh gosh, it's so broken. Having this working group as an executive group, in my opinion, is the first step we have to actually having quantifiable, reliable, structured deadlines, which will make this process actually improve. And I want to be really clear, the competency restoration piece is broken. We've been talking about insanity. This large group of people, 60% of these defendants, aren't getting competent. They don't even get a chance to plead insanity. Because they're not competent, they can't plead insanity. They can't go to mental health court. They can't take a very favorable plea bargain. Their case is over. And I want to be really clear that folks who are concerned about public safety should be very concerned about this. Those folks go to court, the judge hears that they're not competent, not restored, they leave. They leave. They're not held. They simply go. And again, we're hearing from NAMI, we're hearing from New Hampshire Hospital, we're hearing from all these other folks that there's this high risk of continued homelessness, continued drug use, and rearrest. At no point has there ever been a discussion that this is something that was a fly-by-night issue. It's just time, and I think everyone on board is now saying that we need help structuring ourselves and having some sort of authority telling us to sort of show up with the actual work product.
So I would just say comment about what it's like from our perspective and having to explain to victims. And for us, it comes up in murder cases that someone commits a murder and maybe there are multiple victims involved. That perpetrator is not found competent to stand trial. And because of the system or the lack of the system we have in New Hampshire, within a year, if the court determines that person has not been restored to competency, which as Dr. Bader said, in 60% of the cases they're not, that person, unless they've been civilly committed, walks out the door. And that's a very difficult discussion to have with family members about why it is that there will be no day in court, essentially, for what happened here. I also want to explain that competency to stand trial is different than criminal insanity. Competency to stand trial is whether or not the person is capable of assisting their lawyers and understanding the legal process. And competency to stand trial can change. Somebody could initially be competent, but then they're not taking their medication, not getting treatment, they could become incompetent. They could become competent again and incompetent again. Criminal insanity is a snapshot of one moment in time. Was that person criminally insane when they committed the crime? So it's two very different things. And that's why it's important to have very clear standards about one versus the other. The standard for competency is pretty much universally the same across the country. There's pretty much one standard everybody's developed. For the criminal insanity test, there are essentially 4 different versions of it across the country. And New Hampshire uses a version that no one else uses. The original bill was well-meaning to change that definition of insane. The problem is that it would have changed the definition of criminal insanity, and that's what got our attention. And the reason that matters is because you have cases already in the pipeline where one standard's being used. Lawyers, practitioners across New Hampshire, you know what a certain standard is. Judges do. There are jury instructions that talk about that standard. And we just thought it made sense to really think before we change a standard that we've used for hundreds of years in this state. And so the standard for criminal insanity in New Hampshire is this. Did the defendant have a mental illness that caused them to commit the crime? That's the question. That's the standard in New Hampshire. And so it's different than are they capable of assisting their lawyers, which is the competency standard. So I just want to tell you there are two very different things. And the commission would look at the competency issue. Should we put a process together that helps people become competent to stand trial? And on the insanity piece, it would be, should we keep the definition of criminal insanity that we have or change it? That doesn't mean you couldn't change that definition that's on the books about insane, because you can have a civil definition of insane, but the criminal defense definition could be different. And so again, that's why we jumped in when we saw that. But I wanted you to understand the kind of the scope of the issues here and why it matters, at least in the criminal justice system. And we'd be happy to answer any questions that anyone has.
Just when I teach about this, we always say competency is current. So when you think competency is current, and then insanity is in the past. So when they were arrested, were they sick at the time when they were arrested? Competency is current.
And competency can change. Insanity is a fixed point in time. You're either insane or not insane when you commit the crime. It can never change.
And we'd be happy to answer any questions.
Yep. Are there questions for Attorney Strelson or Dr. Bader? Representative Simpson, did you have a question?
I do. Thank you, Mr. Chair, and thank you for taking my question. I think we're hearing from you some understanding of why this either commission or working group needs to be so big, but I just want to drill down on that for a minute. And I think what I'm hearing from you is that many of you on this list don't always agree about these issues, and your hope is that if we as a legislature guide you, direct you to all be in the same room for the same amount of time with a fixed deadline for change, then you would be able to come to some kind of agreement through rigorous work and conversation and compromise and negotiation and all of those things. Is that true?
Yes, and I think what's true is that we actually haven't all been together. There's been, even when judges call meetings, we can't get everybody together. The mental health system is so separate from the judicial system that it's hard to get all of us in the same room. So we haven't really all been together about these topics.
The other piece is that someone could have an idea, very well meaning to change something, but not realize it could have ramifications in another area they're simply not fluent in. And so, like I said, changing the civil definition of insane and not realizing that the definition you punch in will change the definition for criminal insanity. That's part of the reason to kind of get everybody in the same room. Not so much because we disagree, but just to make sure, that's a great idea, but if you do that, that's going to affect me over here. Let's coordinate that better and think about why we want to do that. I think that's part of the thought process behind this.
I want to add to that, as clinicians, we don't always think about wording the same way attorneys do. So things like and instead of or can change entire definitions. And so that's why we need everybody there together.
And the doctor shakes her head at us.
Tell me about your dream. No.
Other questions? Representative Notter.
Thank you. And thank you for taking the question. There's 50 states. So do the other states have this issue as well? Or is there a state that has it all nicely worded?
For competency or insanity? For both.
Both.
So good question. So like we said, the standard for competency is pretty much the same in every state. In terms of getting people restored to competency, every state has sort of different versions. I think we would need a New Hampshire specific version of how to best do this. We have proposals that we've been discussing as a large group, but again, the mental health centers haven't really been able to weigh in on if those are realistic, and we would need their assistance. So we have a lot, thankfully, because we have no system, we're not fixing something, we get to build it from the ground up. And that's a great position to be in because all other states have shown us what works and doesn't work. We can take the best bits and build what I think would be New Hampshire's ideal version that's both efficient and economic and the right thing for what we need. And in terms of insanity, yeah, I think there are different standards. And so some states have chosen different standards. And again, we could look at see what would be the best fit for New Hampshire. Some people are not necessarily dissatisfied with our current standard. Again, the language needs to be updated. But I think we've never really had as a group a good, really targeted discussion about what it should be. I wouldn't say that any one state is the shining example. We would have to pull from a variety of solutions.
I mean, right now, the system that we have for restoration of competency is so lacking that anything would be an improvement. So you could certainly look at what other states do. And as far as the definition for criminal insanity, the definition from our perspective works fine. The question is, can you separate it from the civil definition just to make clear that one pertains to one area, one pertains to the other, instead of making a definition that pertains to both that then turns around and does this major upheaval in the criminal justice world about what the definition of criminal insanity means.
Other questions? I guess just in terms of the mechanics here, it says that there'll be a minimum of 10 meetings within a calendar year, but you have to make a report by November 1st. So is there a need for 10 meetings in a year?
Maybe instead of, I can't remember if it says you shall have. I mean, it could be that you may have.
Shall be
To be
held.
the lawyer, if we could turn it to may.
Yeah.
Because that essentially means there's 1 month without a meeting, and here we are in April, so.
Doesn't make much sense.
Certainly, we can reach that number by doubling up in a month, of course.
I mean, I think that's something that you can leave to the senators who are so excited to be joining. But I will say that I think, again, having that structure, we haven't been able to have monthly meetings with all those necessary stakeholders. So having that due date and maybe splitting off into smaller groups and having drafts, all of those things would be so much valued structured, in our opinion.
Why shouldn't we just appoint Dr. Bader as the chairperson?
I can answer that honestly. I can answer that honestly. I would say that most people in this room, I think, will tell you that I've been a chief advocate for competency restoration since I've taken this job, and I have not achieved anything. I feel like I'm a strong voice for why we need it, and everyone, again, is in agreement, but we have nothing. We have no paperwork. We have no legislative proposals. And we've tried pilot programs. We have tried a variety of things. I've worked closely with SAMHSA, which is a big national organization, to try to get assistance to come to New Hampshire and help us with this process. We still have nothing. So I would love to tell you that I could chair something and it would happen, but I've shown that I can't. And that's why we need this unwieldy group, because this is one of those things that needs all the silos coming together to work on the one goal.
And I guess the only other question I have is, basically, as I look at the amendment and I look at the original bill, it's in essence the same committee. The only difference is who's going to convene it, that I can see.
Yeah. I don't think there are any substantive changes.
So it gets changed from a legislative committee to an executive committee by virtue of who's going to call the meeting.
I think that reflects our desire to actually have some movement and change. I think there is momentum behind this topic, and I think we understand that the time pull for all of you is dire, and so we don't want your time needs to necessarily block the continuation of these processes that are really necessary.
Okay, any other questions? Representative Smith? Actually, Representative McLean, did you have a question? Okay, Representative Smith?
I am flattered on behalf of the legislature that you think we can change human behavior. We can't. Just want to make that clear. When I look at this saying, working group members shall be appointed within 30 days, you shall meet, I think it says within 45 days, there shall be 10 meetings. Each of us sitting here could list a dozen different entities that we're familiar with where that same or similar language exists where nothing is happening, including the chair not calling the first meeting. Do you really think that by the legislature passing something like this, that the problem, the serious problem that you're facing, that I think all of us recognize, is going to get resolved?
I think it's important to start trying. And that's, I think, what the bill, my understanding of what the bill is trying to do is to simply start the process and try. So again, from our perspective, we support it because it is an attempt to get people together in a room to address this serious issue and to make sure that all the voices are heard so that nobody comes back here with a bill and then there are people lined up to raising their hands to speak to say why you shouldn't do it. And the question you may all ask is, why didn't you all get together and figure this out before you got here? So I think it's an attempt. We all recognize human frailties, but I'm an optimist, so we're certainly willing to give it a try.
Okay, Representative Chase, did you have a question?
Thank you, Mr. Chair, and thank you for taking my question. It's kind of a piggybacks on what Representative Smith said. I was thinking the same thing, and also, so all of these entities that you've been talking about are all on board to do this. You're just saying you need direction and you need someone to put the hammer down and say, this is what you have to do. And if that's the case, is everybody in agreement that they're going to be able to do this? And is it just taking legislation in order to make that happen?
I think too, I think the hammer is meaningful to me. I mean, I think that's true. But I also think there's been discussions right among us saying this is an important topic. This is an important topic. This is an important topic. But the status quo has been the way it was for a very long time. So I think in my experience too, having the legislature say, no, actually, this is important. We do want you to meet about this topic has a lot of meaning to this group. And I will say that I agree with you, this question about, well, will people show up? I found that when judges say we're going to meet, people show up. When we're saying we're meeting about this legislative, post-legislative bill such and such, 392 passing, we're meeting. That carries a weight that clears people's calendars a little bit more than just, hey, Dr. Bader would like us all to meet and she's going to bring donuts. That hasn't worked so far. So I do think there's a hammer here that is valuable. And again, I think there's also that piece too, that we're really hoping that, and I do feel close to this, that I think if we have all these people in the room, we have existing drafts of potential legislation, we have to get agreement about how we think about those moving forward. We could come back next session and say, here is our first step. And we all are in agreement, everybody in the room, all these different people who never agree are all in support of this. And we wouldn't have to sort of haggle and haggle and haggle. I do believe that we are close to that because there is agreement. It's just these details.
Can I just also say that, like all of you, right, everybody fights for space on our calendars, and we all give priority to certain people. And for me, and certainly us in our office, they'll say, well, we have a legislative committee meeting I've got to go to. That certainly would allow me or someone else to be like, I'm not going to do those 10 other things you want me to do, and nobody's going to give me grief. So I think it helps all of us meet those requirements like it does all of you. So I just throw that out.
Any other questions? Thank you for your testimony today, both of you.
Thank you for your service.
Thank you for the questions.
John DeJoy.
Thank you, Mr. Chair, members of the committee. It's a pleasure to be before House Judiciary today. For the record, my name is John DeJoy. I'm here representing the New Hampshire Psychological Association. The New Hampshire Psychological Association represents psychologists across the state of New Hampshire. I'm pleased on their behalf to support this important legislation. The Psychological Association respects the breadth of stakeholders that are listed in this legislation. One thing we note, however, is that there are few clinicians that are actually represented in this list. There are a number of important people, and for that reason, we would request respectfully to add a forensic psychologist specifically. I understand Dr. Bader is a forensic psychologist, She's not a named member, although I suspect she will end up being a member of this, and she should be. But we would ask that a forensic psychologist named by the New Hampshire Psychological Association be added to this list. And while it may seem unwieldy, some of the largest groups often end up with some of the finest work product before this legislature. I would refer the committee to the submitted testimony of Dr. James Bombersbach. Dr. Bombersbach is a forensic psychologist. He's also a board member of the New Hampshire Psychological Association, and he has outlined the concerns of NHPA far better than I could as their representative today. And I think you'll find his testimony instructive. With that, I'll conclude my testimony.
Thank you. Are there questions for Mr. DeJoy? Representative Smith.
Thank you very much. Mr. DeJoy, do you have an opinion as to whether we should stick with the language in the original bill, which was to create a commission, or I don't know if you've seen the amendments that Senator Sherman submitted, in which he suggests an executive branch working group.
Thank you for the question. I, as you know, I always have a number of opinions. I'm careful today to represent the opinions of the New Hampshire Psychological Association. What I would say in response to that is and I've read briefly Senator Sherman's amendment. I was puzzled by why the legislature would be directing the executive branch to form this type of committee, when the executive branch is fully capable of forming this committee on their own without the legislature's input. I do believe that the gravitas, and I heard your question before, Representative, I believe the gravitas of the legislature is important in this, which is why I would suggest that we ought to stay with a commission. You know, it's interesting. Several of you commented that you can't make people do anything. And I think that's absolutely true. But when the legislature speaks and forms a committee, what I find is you don't do anything to make people be there, but you raise the bar where people are afraid not to be there. People are always more afraid of what's going to happen if they're not in the room. For that reason, I think the gravitas of the legislature makes this commission valuable. And it's why I'm here before you today representing NHPA, asking that one of our members be added to the membership list, because we believe this will move forward and will produce, as I said, a fine work product going forward.
Other questions for Mr. DeJoy? Seeing none, thank you. Is there anyone else who would like to testify on Senate Bill 392? Seeing no one, we will close the hearing on Senate Bill 392 and thank everybody for coming and participating today. We will move on to our next item of business today, which is Senate Bill 339, relative to meetings of boards and commissions in the Department of Safety. Senator Prentice. Thank you. Good afternoon.
Good afternoon, Chair Gordon. Good to see you again, twice in one day. Members, Chair Gordon and members of the House Judiciary Committee, for the record, my name is Sue Prentice. I'm the state senator from District 5, which represents 9 communities in the beautiful Connecticut River Valley of New Hampshire, right on the Vermont border. I'm here today to introduce Senate Bill 339. This bill exempts certain volunteer boards at the New Hampshire Department of Safety from the physical quorum requirements of RSA 91A while putting in place measures to assure transparency, public access, and participation. I'm going to name the boards in a second, but I want to make sure that I go on the record saying that I worked on this bill in collaboration at the request of the Department of Safety, and that years ago, I had the honor of serving as the chief of emergency medical services for the Department of Safety, and I worked with these boards. And at that time, so I left the Department of Safety in, say, 2010. So all during the 2000s, I would hear from volunteers at all different levels, including, volunteer EMTs through to physicians who served in different parts of the state that always wanted to be on these boards as well as attend these meetings, and couldn't leave their community sometimes for, the day that it would take for them to be there to actually serve. So I think one of the things we all learned during COVID-19 is that in doing some of our business virtually, with putting the necessary transparency and public access requirements in place, we saw more public input, but also we experienced, and particularly on these boards, and a member of one of these boards is here today to speak, more people were actually able to attend the meetings. And I'll talk about why that's important in just a second, but briefly, this addresses 4 different groups. So one is the Fire Standards and Training Commission that's established under RSA 21P25, the Emergency Medical and Trauma Services Coordinating Board at the Department of Safety, which is established under RSA 153A3, the Emergency Medical Services Medical Control Board at the Department of Safety, which is established under 153A5, and the Trauma Systems Trauma Medical Review Committee, which is also at the Department of Safety under 153A8. Each of these boards dedicates hundreds of hours to assure that emergency medical services and fire organizations in New Hampshire are practicing and delivering services that meet the highest standards. Each volunteer member sacrifices time away from work, time away from home, and many travel from the furthest reaches in New Hampshire in order to be sure that decisions are made with input from all geographic locations. And again, during my time as the chief, although we did have representation from these different geographic locations, they'd be named to these groups, but they couldn't always, again, get away from their hospitals or their ambulance services. And they would ask about this. And then it seemed so foreign, but now it's almost so regular. And that's why this was a specific request to come forward. Now, by allowing these exemptions, I believe that we will increase the number of volunteers from the most diverse locations in New Hampshire that will be able to serve, increase the likelihood that these volunteers will serve more than one term, and increase the input from the public and the disciplines that these boards serve. I'd like to note, in terms of serving more than one term, there are term limits for each of these positions. I don't believe there are for the Medical Control Board, but there are for all of the other. No, there is for the Medical Control Board now. So they all have term limits, but what we have seen happen, and it happened during my tenure, is it was such a huge commitment. And when it required travel from, close to the Canadian border to represent the EMTs from that area, or sometimes even down on the, we think of the seacoast as being close by and more metropolitan, but still when somebody is volunteering and traveling and coming in to work on one of these different boards, it becomes, a day-long plus commitment. So in order to get them to serve for more than one term, to provide some consistency in policy making, I think that this, again, is a real step in the right direction. So during the Senate, when this was heard in Senate Judiciary, there were some concerns that were raised about, basically the 91A requirements. And I wanted to make sure that although in my mind, these would be covered, I thought that it was important to take the same steps that we took during the pandemic for how these meetings were conducted, so that the express transparency was there. So this bill is now amended, and it includes a physical location. So if people can come to a meeting, we're not expecting that these meetings will come completely virtual, but folks that can come to a meeting will be in a physical location, but it could be opened up to people outside who are members of these boards, as well as members of the public who want to have input. It requires public notice of meetings. It requires public access for participation. It requires that minutes be taken and posted for public review on the Department of Safety's website. And it also it requires a roll call vote if there is any type of policy decision made, say the updating of a patient care protocol, again, for the highest standards of care that are available, that we really want to make sure that we keep the public care and the public trust front and center here. So considering, again, my time working with these boards, which again, I was really honored to serve in that role, I can think of very little that any member has ever asked for. It's time we honor the work of those who have served in the past, those serving now, and those in the future with making these changes. So with that, I'd ask for certainly an ought to pass recommendation. I'm happy to answer any questions you might have. And if I don't have the answer, I'll get back to you.
Questions for the senator? Yes, Representative Chase.
Thank you. Right now, so the meeting place is the Department of Safety here in Concord, is that? And
Correct.
everybody tries, and how often are those held?
Every other month, so it's 6 times a year. It's 6 times a year for the medical boards. The Fire Safety and Training Commission, I believe they meet monthly. And they do travel in. There was a period of time when I worked at Safety where we did take these meetings on the road, but it became really complicated in doing that when you were trying to notify the public for this meeting will be now at this location. So we just reconsolidated back. So at least 6 times a year for the medical boards and 12 times a year for the Fire Standards and Training Commission. You're welcome.
Other questions? Representative Andrus.
Thank you, Mr. Chair, and thank you for taking my question. During the past 2 years, I have been to many Zoom meetings, YouTube, everything. One of my biggest drawbacks is the YouTube might not work. You can't hear the meeting, and this happened more than once. On a Zoom meeting, the people that are supposed to be in the room conducting the meeting, they do not get close enough to the mic, so you can't hear them half the time. That's my biggest drawback. How do we solve it?
I believe that, thank you, Representative Andrus, for the question. And so on page 2 of this, and this is actually part of, I skipped over this, but was part of how we amended it in the Senate. It provides a mechanism for the public to alert the public body during the meeting if there are problems with access. So certainly I've attended more virtual meetings in the last 2 years. And even before that, I worked in a remote position for a group called the American Trauma Society, which supports trauma centers throughout the country as well as here in New Hampshire. So I have a lot of experience working in the virtual setting. And by having that mechanism in place where there's a notice for how to alert those that are controlling the meeting that there is a problem, or that you know, which includes maybe they can't get into the room, maybe they're not being heard, they're not close enough to the microphone. There is a way to have that conversation. So there's a phone number or a connection that they can make right away outside of that virtual connection to say there's a problem with this meeting. Thank you very much.
Other questions? Representative Horgan.
Thank you very much, Mr. Chair. Thank you very much, Senator.
That's okay.
I'm reading, well, especially paragraph 4 and page 2, and then the rest of it. It looks like this bill only guarantees the general public, basically telephone or video streaming access to the meeting, so they don't guarantee the general public the opportunity to actually be in the room. And I think there probably are cases, especially if they're meeting the Department of Safety under certain circumstances, where the Department of Safety might want to limit how many random people from the public are physically in their facilities. So is this intended to guarantee all meetings in-person access, or are you only going so far as to grant them video or telephone access?
Without virtual access, so thank
Yeah,
you, I'm Representative Horgan, and I think I've seen you 3 times today, so good to see you again.
Oh, good to see you then.
So this is a great time of year. We get to all see each other, and so I really appreciate this opportunity to be here in person versus virtual. But during a time when we needed to do that, that's what we did. So to answer your question, if we didn't even have this, all of these folks would have to be in person. By doing this, and if language needs to be clarified, I'm happy to do that. It says virtual, which allows for any, whether it's by Zoom, YouTube, however it's going to be broadcast, it's a virtual platform. It's not been my experience when I worked there, that we limited the number of people in the room unless, there's an occupant. So some of this comes down to the local fire departments and stuff. There's a certificate that says how many people can be there. So that includes the buildings at the Fire Academy in Concord. So if they were to go over that, then it would have to be, what do we say, marshaled. Thank you.
Other questions? I guess the question that I'm wrestling with is, we have this bill, we've had a bill earlier today with regard to allowing particular groups to have remote meetings. We had bills last year with regard to specialized groups, or earlier this year with regard to have specialized groups having an exception for remote meetings. The issue that I'm having is, shouldn't we as a state be adopting a policy rather than doing a onesies and twosies for individual groups? Shouldn't we have or be adopting an overall policy with regard to remote meetings?
Thank you, Chair Gordon. I couldn't agree more. But when I filed this bill, there didn't seem to be an appetite for moving in that direction. And so what I did take was a step to, and I know that others did it this way too, to take these particular boards and get them hopefully across the finish line. But I think our larger goal needs to be that we have to revisit the entire conversation. So I couldn't agree with you more, but there didn't seem to be an appetite for something that was more broad, that involved the state and state boards. So I narrowed my focus. That's the only reason why I did it this way. But I would be open and happy to, work on that type of legislation.
Thank you.
You're welcome.
Understandable. Other questions? Seeing none, thank you for your testimony today.
Thank you very much. And again, if you have any questions that come up later, you know how to find me.
We'll
I'll be
find you.
here. You're welcome.
Eric Martin.
Good afternoon. I'd like to thank the board for their time today. Eric Martin, I'm the trauma surgeon at Dartmouth-Hitchcock Medical Center. I'm also the trauma medical director there, but today I will be acting in my role of the chair of the TMRC, the Trauma Medical Review Committee, in support of this bill. I feel, excuse me, for some background, I can only speak to our committee. I've been a member for a long time. We are assigned the task of maintaining the trauma system within the state. By doing that, we focus on the four concepts of the pre-hospital care, the hospital care itself with designations of hospitals, the rehab part of this, as well as injury prevention. So our meetings encompass all of these groups. They all provide information and allows not only the committee members, but the public to ask questions and comment. It's a great group that does this, as Senator Prentice has said, on their own time. We underwent a state review, or a review of our state's trauma system by the American College of Surgeons several years ago. And one of the things that they were impressed by was the quality of the trauma system that we have, and impressed by the fact that the majority of this is done by volunteers, but cautioned against the longevity of that because people's time is harder and harder to come by. I think, as Senator Prentice has mentioned, this has been a challenge before the pandemic. We do outreach, we do education throughout the state. And every time you go to a small hospital, they are interested, they're engaged, but trauma is a small part. We were in Colebrook last July, great people, wonderful facilities. They are very engaged, but it's very difficult for one person who wears many hats to leave their institution for a day to drive down, even if it's only every other month. I think pandemic has broadened our abilities to engage and capture more people. But I agree with everyone that there needs to be a physical location. I personally feel it's much easier to have conversations and engage and interact with the physical location. I think having that as an option is very important. But we missed 3 of our meetings last year because we couldn't get a quorum, and we only need 9 people. People have gotten very used to scheduling their time such that they can block off an hour and a half for a meeting. But it's very difficult to kind of go back 2 years to where you had your half your day open or your whole day open. So I think our group is such that everyone is engaged, and the key players will continue to want to come, but it does allow for that option to say, we need one more person to attend to have a quorum. Can someone call in and just be a part of that meeting? And I think that would be helpful to allow us to sort of move forward and focus on our efforts. And I think, I do appreciate that having a physical location. Our meetings are, I believe we have 17 voting members, but we routinely have 50 or 60 people in the room. And those public members tend to be people who are engaged in medical care, but they are public members, and many of those non-voting public members provide a lot of the services that we do, such as the designations. So I think we've never had a situation, and I would welcome a situation that we had, not enough room in our rooms. We've never had a standing room only crowd. I would love that, but I think space has not been a challenge in the close to a decade that I've been part of this group.
Questions? Yes, Representative Chase.
Thank you. Thanks for taking my question. So tell me, when you're having your meetings, you said that you had missed 3 meetings this year, and because you didn't have a quorum. So what happens? What is it that you are trying to vote on, and does it get curtailed and tabled to the next meeting?
So when our meetings, we have subcommittees that often meet at the same time. So the subcommittees are responsible for designating safe hospitals. They're responsible for working on the pre-hospital care, and our education subcommittee, which is trying to more and more work on outreach. So I feel the last meeting we had in person, I was finally able to get caught up, but I almost feel like I lost a year because it's difficult when you meet every other month to sort of keep the momentum going. But if you miss 2 in a row, which unfortunately we had, it was very difficult to sort of get back to where we were trying to go. Our efforts the past several years have been, there are 26 hospitals within the state, only 11 of those are designated, but everybody really is participating in the acute care of injured patients. So our goal is to engage every facility at some level, and we've been working in that direction to sort of change how we're utilizing our resources, but that does take committee votes, and it's just has sort of stalled, and we've lost yet another year. So.
Other questions for Mr. Martin? Representative McLean.
Thank you, Mr. Chair, and thank you for taking my question. On the second page, paragraph 4 says that a physical location is required, but it doesn't require that any member of the board actually be there. So while you might have a physical location, it would allow literally for nobody to physically show up to interact with the folks of the community that might be there. Do you have any particular thoughts on that?
I do, and I do feel that, again, I can talk to Senator Prentice about this. I don't want to change her language, but I feel that, like most things, 100% of achieving even 6 meetings a year can be challenging. Everybody has problems. Even if you have a requirement of 2/3 of the meetings have to be in person or something, I can do all I want to encourage people to attend in person as the chair, but if the language is such that they could all attend remotely, I guess there's nothing that would stop that direction. I do know that many of the attendees, the volunteers and the voting members, use this as a time to sort of resource with each other. And I think that physical contact has been a strong suit of this. And I think I would consider that, or suspect that would still go forward, but I share your concerns as well. We don't know what will happen in 5 years. And if there's some language that suggests that the majority of the meetings must be in person as a voting member, that at least brings that core there routinely. Again, that's just me. I'm not speaking for Senator Prentice on that one.
Thank you.
Representative Macbeth.
Thank you, Chair, and thank you for taking my question, Dr. Mark. You articulated something very well. You said, I feel it, but I think you said people are getting used to spending 90 minutes on something instead of a half day. But I'm wondering for you, when you're participating in a virtual meeting, are you less engaged or less likely to follow up with people that may have questions, or do you notice with your colleagues on boards that they're less committed to their service on that board?
During the pandemic, I hadn't noticed that at all. I think everyone is just as engaged on the meeting. I think there are some technological challenges even still with 2 years into this. But I felt like the work that was being done during those meetings was still effective. I think it allowed for some growth in some ways to be able to do that without, otherwise we would have done nothing for a long period of time. But I didn't get the sense that people were less engaged. I feel the key point is having an ability for people to sort of raise their hand electronically or ask questions is you have to have that. You can't have a public meeting or any meeting without the ability for people to speak up.
Thank you, Dr. Markin. Thank you, Chair Gordon.
Any other questions? Just following up on what Representative McLean had asked, would you have any objection if there was a requirement that the chairperson of a meeting be at the physical location?
I would not, although I did miss the December meeting for reasons that I could not. Our hospital was being reviewed by the American College of Surgeons, so that was one meeting I could not make. So I think if you wanted to have the language that either the chair or the vice chair should be present in person, I think that would allow for some leniency, because when you miss one meeting a year, that's a lot.
So if we were to say the presiding officer, regardless of
I think
who
that's
it
a
might be.
reasonable ask.
So if the public is there, they would have someone to address.
Exactly.
Thank you. Any other questions? Thank you for coming today.
Thank you for your time.
Is there anyone else who would like to address the committee with regard to Senate Bill 339? Seeing no one, we will close the hearing. Our next hearing isn't scheduled until 3 o'clock, so we will be in recess until 3 o'clock.
No. I don't want any hot mics.
Good afternoon, everyone. We'll call the House Judiciary Committee back to order. Thank you. Our next item of business is a hearing on Senate Bill 217 relative to eviction notices. The prime sponsor of that bill is Senator Perkins Quokka. And Senator, would you like to introduce the bill?
I would. Thank you, Chairman. Hi, Representatives. Nice to be with you again today.
Thank you.
You have a much longer day than I do. For the record, I'm Senator Rebecca Perkins Quokka from Senate District 21, representing Portsmouth and the towns of Madbury, Lee, Durham, Newington, Newmarket, and Newfields. The prime sponsor of SB 217 relative to eviction notices. SB 217 is a piece of legislation that I worked on with Elliot Berry from New Hampshire Legal Assistance. As amended, this bill will expand the minimum amount of notice needed for a renovation eviction from 30 days to 60 days. In such a tight housing market, with vacancy rates hovering between 0.5% and 1% around the entire state, it can be next to impossible to find housing in 30 days with the threat of an eviction hanging over your head. This bill is designed to provide a cause of action for tenants in cases where a landlord indicates the eviction is for the purpose of renovating, but does not in fact pursue any renovations. This is clearly not every landlord. In New Hampshire, we are lucky to have small, local landlords, and everyone has an interest in preserving that. This bill is designed to provide some remedy to the tenant who is evicted under other good cause, leaving them little recourse. I hope that this bill will give individuals and families already facing a dire situation just a little bit more time in which they could either find a new place to live or find assistance to help them catch up on any potentially late payments or find another avenue for resolving their conflict with the landlord. We all know that the lack of long-term housing supply is the real underlying problem and one I have personally been working on for over a decade. In the short term, however, over 50% of our renters were affected by COVID-related job loss, and we need to continue to ensure that we do everything we can to make our housing market fair. SB 217 passed out of Senate Commerce with a unanimous recommendation and passed the full Senate on a voice vote. Thank you, Mr. Chairman. I'll leave it there, and I'd be happy to answer any questions.
Are there any questions for the Senator? Representative Smith.
Mr. Chair, Senator, as I read this, I'm obviously missing something. The evictions here have nothing to do with non-payment of rent. They have to do with circumstances that where the landlord desires repairs or is required to make repairs, et cetera, et cetera, et cetera. And yet you alluded to non-payment. So can you help me understand that?
Thank you. Thank you, Representative, for the opportunity to clarify that. That was included in my statement. You are correct to read the language of the bill to address the limited circumstances where we're inserting into RSA 542 Roman numeral 2, paragraph H, which does address the specific circumstances you're talking about when the landlord desires to perform repairs to a dwelling unit when the tenant cannot safely be in there, perform a substantial renovation, or to sell. In those specific cases, the 60-day notice is then inserted in paragraph 2 with certain exceptions. So my apologies for that being included in my statement. Must have been an oversight.
Other questions for the Senator? Representative Chase.
Thank you very much, Mr. Chair, and thank you for taking my question. This is more, I'm just thinking of bills that we've had already before us. And I could be, try to pull from my memory, it might have been a lead paint removal, but we had one where, landlord has been ordered to make the repairs and then has to put the tenant in a different dwelling, whether it be, say, a motel or something short-term until the repairs are done, and then that person would be able to go back to the housing. Is this not at all considered in this bill?
Yeah.
I'm reading line 12, actually.
Yep. So if you come further down, yeah, that's all right. No problem.
Other questions? Seeing none, thank you, Senator.
Thank you very much.
Elliot Berry.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Elliot Berry. I'm an attorney at New Hampshire Legal Assistance and the director of our Housing Justice Project. I've been representing tenants in New Hampshire for over 40 years, and for some of you, you probably feel like I've been coming before you for 40 years. I think I've been here enough so that you probably know what an incredible shortage we have today of housing that certainly even middle income people can afford. And certainly in rental housing, it's absolutely the worst situation I've seen in my 40 plus years here. The median rent for a 2-bedroom apartment is just $2 shy of $1,500, and a vacancy rate statewide of less than 1%. So at the same time we're in this market, we have seen a major spike in evictions where the reason is that the landlord wants to renovate the property or that the landlord wants to sell the property. And the problem, is that in these cases, the tenant is in no way at fault whatsoever. But in this market, they may very well end up homeless after living in a place. Especially, I have a lot of elderly clients who have lived in their apartments for 10 years or more, and the new landlord comes, and I get it, he wants to renovate the property, but should these folks really be threatened with homelessness? Remember that for elderly housing, the wait lists are minimum a year and a half. For Section 8, where you have a subsidy that you can use in the private market, you're talking about wait lists of 5 to 10 years. So people just have nowhere to go. And I will say that, again, that this market is the worst that I've seen. But I want to be really clear with you. We have never had enough rental housing at prices that lower income people can afford in my entire career here, except during the savings and loan meltdown around 1990 and the Great Recession in 2007. But other than that, the market is just usually hostile to the people who need housing and can't afford it. I want to stress, and this is really very important, this is not about bad landlords. It's not about punishing anybody. It's simply about giving people a little more protection, a little more time, so that that extra day or an extra week or an extra month might enable them to avoid going to a homeless shelter or moving in with people who don't, with relatives. You need to understand that this only applies to what the law currently calls restricted housing. And what that means is if you're renting out your single family home and you don't own more than 3 at any one time, you're not affected by this bill at all. If you live in a building, an owner that you own, and you have 3 rental units or less in that building, this bill does not have any effect on you whatsoever. For the bankers in the crowd, more properties at mortgage foreclosure are also exempt. And this is not new exemptions, it's exemption in the current law in the definitions of restricted housing. So what does the bill do? Simply, it says the eviction notice that's required when you give somebody, when the reason for the eviction is rehab of the building or sale of the building, it simply extends the eviction notice from 30 to 60 days. The Senate, by voice vote, passed an amendment. We had submitted the bill at 90, but I can't stress to you, I just had a client who I made an arrangement for to get her about 3.5 months to move after she had been in court for the eviction. When she got within 2 weeks of her deadline and drop dead date, she's still peppering me with emails. She has absolutely nowhere to go. Finally, in the last week, she got a break and she was able to move. But I guess what I'm trying to tell you here is, yes, there is no question that this will make landlords of restricted property, it will maybe lengthen the time it will take them to do rehab or to sell a place. But what I beg you to do is to consider balancing the harms. On the one hand, you have people who are being evicted through no fault of their own, who are facing the imminent possibility of homelessness. And on the other hand, you have investors in landlords who simply, who want to renovate and rehab their property. But if you balance those harms, I don't think it's a close call. Now, let me say one other thing that the bill does that should be of some help. If the repair is necessary, because to remedy a condition that's a violation of the housing code, the owner can go ahead as if this law didn't exist. As long as if the landlord first has to ask for an extension, if they can't get it, that's it. If there's a lead issue, this doesn't affect the lead law, which has a separate provision about evicting people from lead apartments with lead hazard. It doesn't affect them at all. I have 3 letters that I'd like to just distribute. One is from Stewart Property Management, who they own 2,500 units in the state of New Hampshire, and they support the bill. The next one is from Lakes Region Community Developers. They support the bill. They have over 370 units. The third one is from Charlene Lovett, the former mayor of the city of Claremont, who's also on the Claremont Housing Authority, and they support the bill as well. So I'd be happy to answer any questions. I'm sorry if I went on a little too long, but I just urge you to balance the harms and support this bill.
Questions for Attorney Barry? Representative McLean.
Thank you, Mr. Chair, and thank you for taking my question. Are folks that are evicted under this particular reason, do they still preserve the same due process rights if they're evicted for other reasons like non-payment of rent or things like that? So do they still have the same due process?
The procedure is exactly the same. But if I could add, which isn't exactly the answer to your question, one of the problems right now, even though there's a court process, as the chairman knows very well, but one of the problems is when a client gets served with the landlord-tenant writ to start the eviction process in court, that gets scooped up in the landlord reporting system, but the reporting system doesn't report why the eviction happened. All the prospective landlord sees is that the prior landlord filed an eviction action against them, and that makes what is difficult, a market that is difficult, that's one more major barrier to getting rehoused. But I don't know, did I answer your question?
Thank you.
Thank you.
Other questions? Representative Horrigan.
Thank you very much. I saw all these 3 letters you're handing out because I saw them in my email and managed to print them out. So 2 of them, well, first of all, there's Stewart Management and Lakes Region. Those are both landlords who specialize in subsidized housing, so they're not part of the mainstream for-profit landlord community.
No, Stewart is wholly for profit.
Yeah.
Although a lot of their properties do have units in them that are subsidized, but they are a for-profit entity. Lake Region Community is a nonprofit.
Okay, follow up.
You may.
Thank you. Well, thank you for clearing that up. It did seem incongruous for a for-profit landlord to be talking about something that benefits the tenants, but I see why it's a good idea for him to do that. But there's a story in Laconia about a property where everyone was kicked out within 30 days, and then they didn't start demolishing it for 6 months? Do you know anything about that story? Is that
I
a typical
don't
one?
know that story, but I'm really glad you asked, because one of the other problems that I did not allude to is that although most of the time this is perfectly legitimate, but a landlord who wants to evict somebody for some other reason but doesn't want to take that to court, the easiest thing in the world for them to do is say, I'm selling the property, or I'm going to rehab the property. And I can tell you, as a lawyer who's tried to defend, I have to tell those clients, well, how am I going to prove that you can't, that you're not going to sell it or you're not going to rehab the property? It's an invitation for abuse. Now, again, I'm not saying that's real common, but I do know it's out there. And at least by extending the notice period for 30 days, you can discourage that.
Representative Smith?
Mr. Barry, I was under the impression that if someone had a lease, even if the property were sold, the lease continued to be in effect. Am I wrong?
No, you're right about that, but it's just that there's an awful lot of tenants who either never had a lease in the first place, or their lease is expired and they're going month to month. I'd say among my clientele, that's probably the most common scenario.
Other questions? Yes, Representative Kenny.
Thank you for taking my question. And my concern might be off base. So lines 12 through 23 lays out exceptions, and A and B make sense to me. I do have a question about lines 20 through 23. The words health, safety, deterioration are used, but not necessarily defined. So I'm just wondering if without definitions and not that a landlord would, but could those terms be used to justify an eviction when renovation is needed?
I'm really sorry, Representative Kenny. I must have a different copy. Can you? What lines are you referring to?
Am I saying the wrong lines?
Thank you. Gotcha. So I guess if I understand your question is there still the possibility that landlords can be telling less than the whole story about that? Absolutely. And the only way I could prevent that is to do something more draconian. And I'm trying not to have the perfect be the enemy of the good here.
Thank you.
Other questions? I guess the only question I'd have is, at least they were a couple of years ago when I got done, judges had the discretion in the process of giving up to 90 days for people to leave the premises after they determined that an eviction was appropriate.
Anywhere from 7 to 90 days. That's correct.
7 to 90 days. So, and I think it was always my practice to hear from the tenants as to what time they might need to get out of the premises. So is that, presuming that's still in effect, and if it is still in effect, is that not adequate or not practiced?
Well, it's all over the map, Mr. Chairman. I mean, sometimes I would say, though, when I'm sitting in court and just seeing these cases, while I'm waiting for my own, I think especially in cases when you're talking about sales and rehab, my gut tells me that the most common discretionary stay is about 30 days. And is that enough? Often it's not. And it's not because the market is so hostile out there to people who don't, again, $1,500 is a median rent for a 2-bedroom apartment. I mean, I have clients who've looked for 6 months. And this isn't going to solve the problem, but it just makes it a little bit easier. But you're right. Sometimes especially if you have a very elderly, infirm client, right, who the court's going to feel sorry for, sure. Sometimes you will get a longer stay than that. But as I said, I think the most common stay is right around the area of 30 days.
Other questions? Representative Nada, did you have a question?
Sure, thank you. I'm looking over this testimony from 3 different property managers.
One of them's the former mayor of Claremont and a member of the Claremont Housing Authority. The other two are property owners / managers.
And they support the bill.
They
So
do.
my question is, by law, do they have to kick people out after 30 days, or can they offer them?
Oh,
Is
no,
it
they
within the
can-
law to offer them
No,
more
they
time?
they can offer as much time as they want. The law's requirements are the minimum, right? And they're the minimum and the most common. But any landlord who has feeling humanitarian.
Extremely crowded. That's when rental prices went up here, because you had millennials staying in the rental market longer, retirees going into the rental market, and you had 20,000 New Hampshire families face foreclosure, and we didn't build anything. So no, I don't think a sunset provision would be appropriate in this case. Thank you for the question.
Other questions? Seeing none, thank you for your testimony today. Nick Norman.
Thank you once again for the opportunity to speak. You know me pretty well. I am an advocate for landlords. We have a following of 2,500 or more landlords across the state. I'm going to pass out testimony. You can provision this called for in this, which are actually in the range of lines 18 through 23. Someone already flagged out that they're not very well defined. You could find yourself in court trying to defend something that's hard to define. And so then you may find out that case has been, doesn't work. The judge goes against the property owner. And so now the property owner starts another eviction. They started with 30 days, then they might restart with 60. And now it's taking longer and longer and longer. Also, I'll remind, and all of those delays transfer into lost revenue, which transfers into increased rents. Also, I just want to remind, in case people are forgetting, that this is only the first step in eviction. An eviction takes, with a 7-day eviction, takes about 6 to 8 weeks. So if we're adding 21 to 51 days, 6 to 8 weeks is becoming 51 days longer. So there's also the discretionary stays that can be granted. And what we're seeing in the courts now, we're talking about the difference in this market versus previous markets. What we're seeing in the courts now is that pretty well all courts across the state are doing everything they can to extend the eviction, work out agreements between landlords and tenants, use rental assistance earnings, monies if it's the issues with money. So we don't see that we see a lot of harm that would come from forcing 60 days. And there's certainly a lot of confusion in the language. It would depress sales. Anytime that you extend notices, it's going to cause pressure on driving up the rents. It would delay repairs. You know, it doesn't cure the issue. The issue is a shortage in supply. Alyssa was totally right when she said that we haven't been building enough real estate. That's our issue. We need to focus our energy on building more rental housing. And I think specifically workforce and lower income housing. And the way things are in our market right now, with the restrictions that keep coming out and the eviction moratoriums that we just got through, I can tell you, beyond the shadow of a doubt, there are many mom and pop landlords that are leaving the business, selling their properties. And who's buying them? Corporate investors that come in and do renovations and raise the rents. And every time that happens, we lose another piece of affordable housing. So anytime there's more restrictions and barriers put on property owners and landlords, then you're going to see it translate into less affordable housing and higher rents. It would certainly delay repairs for hazardous conditions. All of New England is 30 days notice. I wanted to tell you about my past week, just to give you a sense of the real estate market, because people are talking about how hot and fast and hard it is to get an apartment. In our office, we finally put another ad in the Craigslist, where a lot of landlords put their ads. And it's been a while because not as many people are moving. Because it's harder to find a place. Granted, I absolutely understand that. We put in the ad. Within 2 days, I got maybe 6 to 8 calls, responses to that ad. I had 3 showings, and I had 1 application. That's my real life. It's not a panic. That just happened this past week. Now, I won't say that it's not hard to find an apartment. Yes, there's a shortage in supply. There's no question there's a shortage in supply. And so it is harder for people to find something. But you have to also realize that creating a longer notice from a landlord is going to worsen the situation for affordable housing, because a tenant is required to give 30 days notice. So if a landlord has to give 60, but the tenant only has to give 30, then the tenant that's been given 60 days notice is now out looking. And probably they're out looking right away, because yes, it is harder to find something. But are they finding anything that's available 60 days out or 45 days out? Probably not, because the tenant is only required to give 30 days notice. So now what you're doing is you're creating another demand on the supply. And when you have more demand on the supply for housing, and there's not there, a landlord doesn't have it because the tenant hasn't given them a 30-day notice, then you're going to see more pressure on increasing the rents. It will worsen the situation. What we need to do is make the situation better by having more housing. And I urge you to support all the different bills that come to you that would create more housing. And we're supporting those as well. There's a lot more in my notes, and I could probably talk for 3 hours. So I'll stop. And I haven't covered everything, and I would be really delighted to take any questions, please.
Thank you, Mr. Norman. Are there any questions? Representative Chase.
And thank you, Nick, for taking my question.
Sure.
I just read this one area here that you're saying the bill would delay removing troublesome tenants that is disturbing and threatening. Could you explain to me how this bill is going to delay removing someone that is being disruptive?
Absolutely. So the state has set up several situations that make it hard for property owners. And when you have a tenant that's causing nuisance to the other residents, you can evict them on a 30-day notice, but maybe not, because you have to get to court and you have to prove the nuisance. You have to prove the drug abuse. You have to prove the drug trafficking. I'm sure that our previous judge can confirm that it's very hard to win an eviction case for that kind of a thing, or even domestic violence. You have someone that's a perpetrator that you want to remove because they're actually causing harm to others. You have to prove all that stuff. And almost 100%, if you ask your tenants to testify in court so that you can prove and win a case, they won't. They're too much afraid of retribution. But what you can do, and it's one of the only things that the state allows, is you can say, okay, for business reasons, I'm going to renovate that apartment. That's fine. You can renovate the apartment. I'll renovate the apartment. I'll raise the rents because I renovated. That's the only real choice that's workable that's given to the landlord. And once again, that worsens the situation, because now to get that tenant out, I need to renovate. And of course I renovate. And now I raise the rents. And then I've solved the problem. The other people can live in peace and in quiet enjoyment. But you've got one more apartment that's off the affordable list. I hope that answered your question. Yeah.
Representative Macbeth.
Thank you. Thank you, Mr. Norman, for taking my question.
Thank you for the question.
So is it your understanding that this bill does impact nuisance evictions?
Nuisance. Well, it would impact. So yes and no. So no.
Okay, thank you.
But
And then
but
I have
in the
another
real
question, if I
life of
could.
what I just described, yes.
So I
You
have
understand?
another, may I follow up?
You may.
Thank you. So I'm very curious. I really am about the ad that you put in for the apartment. I know we
Yeah.
got one. I don't base public policy on anecdotes, but because I may want to help you with public relations, would you be interested in, would you be able to supply that ad for us so we could see what the unit was and how much and what the conditions were?
Sure.
Thank you.
Let me
Thank you very much.
write that down.
Thank you.
Otherwise, it'll never happen. Right here.
Other questions for Mr. Norman? Seeing none, thank you for your testimony
Thank you,
today.
and please always reach out to me. Call me in between times. I'm always available for questions.
The next person is Sophia Hyatt, or Sophia. I don't know. Which one is it?
It's Sophia. Thank you
Sophia.
for asking how to say it. My name is Sophia Hyatt, and I'm an attorney at New Hampshire Legal Assistance. But unlike Elliot, I've been there for about 10 months, not 40 years. So, unfortunately, though, in those 10 months, I've had more than 7 renovation eviction cases. I'm going to talk about some of them, but I also want to respond to some of the comments that have been made. With all respect to Mr. Norman, what he just said about using this to evict people for other issues is exactly what we're talking about. And changing it from 30 to 60 days will make it harder for people to do just that. And that's not the purpose of a renovation good cause eviction. You know, there are ways to evict in the law for that. And the court process should be followed and not, manipulated. And we shouldn't decide on how to adapt bills for something like this so that a landlord can manipulate our court system. I would hope that everyone in the room agrees with that. And also talking about corporate landlords coming in and buying up properties, that's already happening. So make no mistake that that's happening already. We're not, if we don't do this, that's not going to prevent that from happening. That's already happening here. And also there was discussion earlier about some of the sections in some of the lines in the exceptions and the 30-day notice exception. I just want to point out that that language that's being referenced as causing confusion is already in section RSA 541 little a. So the alleged confusion is from language that's already in our statute. So I just want to clarify that. So I want to talk a little bit about my work at NHLA. In 2021, our organization had 32 intakes for renovation evictions. That represented 30 different tenants. We had a couple people that brought cases back. We had to reject 5 of those cases. Like I said, I've done, and that was just for 2021. We also do work in the Manchester and Nashua district courts, and we regularly see evictions for renovation in those situations as well. Most people that don't get legal aid don't know that they don't have to move out when their eviction notice expires. Every client I've talked to in this situation is like, all right, well, I'm packing and I have to move out. And we're like, no, you don't have to move out right away. So the idea, a lot of tenants who don't get legal assistance, and remember, I just told you we had to reject 5 cases. I'm sure that'll be, we always are rejecting things. Unfortunately, we just don't have the resources. That there are people who are just going to move out and they don't realize that they can fight it and they think that they just have to leave. So that would really help these people either reach out for legal advice by having a little bit more time or just have more time to find a place. And it is true that 60 days isn't a magic number. People aren't necessarily going to find a place, but it lessens the amount of time that person is homeless, going to your municipalities for local welfare dollars and asking for them to pay for transitional housing. So when people are homeless, they're going to your towns and asking for money. So that's something that you should consider when thinking about extending the amount of time that tenants would have for a notice period. One of my clients was recently, at the end of last year, facing eviction for renovation. He lived there for 5 years, didn't want to move, liked the town he was in, but understood that he had to move. We negotiated a move out agreement. He moved out, and 3 days later, his landlord had painted the property and posted it on Craigslist for $50 more. So this is regularly used by landlords to circumvent the legal eviction process, and you should not be making your decision based on supporting what you know to be manipulation of that process. Another client of mine lived in her apartment. My client's a disabled woman, and her daughter, who's in college, takes care of her. They lived in an apartment for 16 years. Her landlord sold the building, and the new landlord, I understand they talked about, when a new owner comes in, they don't want to make changes. That's not always true. In this case, that's not what happened. And she was evicted. We did negotiate a move out agreement. Even though we negotiated a move out agreement, she still had to move in with another daughter of hers 50 minutes away, which is 50 minutes away from her healthcare providers and appointments. So we're not saying that 60 days is going to solve the problem, but it is going to help people have more time to look for a place. And again, it's also going to lessen the burden on your municipalities that you represent in terms of how much money they have to pay out in local welfare cases. I also have a veteran right now that I work with who is currently homeless. He's living in a temporary housing. He's paying for a 5-day stay at a time. We're working with agencies to try and figure out a place for him to go, and he was evicted for renovation. So this is very real. Again, I've been doing this for about 10 months. I've had, I think I said, like more than 7 cases already. So this is a very real thing. It really affects people, and any extra time is going to help people. Thank you.
Other questions? Seeing none, thank you for your
Thank you so
testimony
much.
today. Viola Cadasimo, is that close?
Good afternoon, members of the House Judiciary. My name is Viola Katsime, and I'm here representing the Garden State Organizing Project. We are a non-partisan organization based in Manchester that bring faith, labor, community members together to fight for social and economic justice. And I'm here today to really express our support for SB 217. At GSOP, we are hearing stories daily from tenants. We've been running tenant clinics for about 6 months now in Manchester and Nashua, and most of those around evictions. Over the weekend, I was in a meeting with tenants in Manchester as well, who have received eviction notices to move because of renovation. I spoke to a single mother with a 15-year-old who doesn't know what to do. She received a letter, her rent is $1,500. Currently, she's getting assistance through the CAP agencies to pay for part of that money. Her rent went up by $600. And now she's being told that she has to move out of this place in 30 days. She expressed that she doesn't know what to do because she's looked around for alternative places and she can't find any place that would take her for that amount of money at the moment. Another family in Manchester that we heard from, it's a mother with 2 kids in a 2-bedroom apartment. They've been living in this building for 12 years. And recently, the kids grew up in that same building, so they don't know any other neighborhood. That's their neighborhood they've been in, and the schools they go to. And so recently, they've been receiving notification as well that they have to move because of the renovation project that's going to take place. We know most of these buildings are actually dilapidated. They are very old, they're in poor conditions, and the tenants in those buildings do agree that renovation needs to take place. But what they're trying to do is trying to find a place anywhere in Manchester, in Nashua, in Concord, anywhere in the States is very, very challenging for these families. And they have kids, they have their resources within the community. So what they're trying to do is try and find those alternatives. The alternatives are not there that they can afford. So this bill would be really critical in helping them figure out what that next step is. So I'm here to urge the committee to consider passing this bill. And so I thank you for your time, and I hope that you will do the right thing and support families in New Hampshire.
Okay. Are there questions? Seeing none, thank you for coming and testifying today.
Thank you.
Jessica Margison.
Good afternoon. My name is Jessica Margison. I'm representing myself, and I am a tenant organizer with Granite State Organizing Project. I also run the tenant clinic that was mentioned previously by Viola, which was a product of going door to door over the past 2 years to try and help tenants understand their rights as it related to COVID now and to get through these mass evictions. I am also on the Manchester Housing Commission to try and help alleviate some of these issues. And what I wanted to speak to about today, a lot of little things, and I tried to gather notes and respond to a few different things I heard this afternoon. What I do want to start with, as Mr. Norman stated, these renovation evictions are being utilized as a quick no-fight eviction when they don't want to go about it as they should and take their chances. I stated this when we were here with HB 217 when it was in the House. I stated it seemed like a knee-jerk reaction to the moratorium that was going on before. They couldn't evict people, they were stymied, and they found a way. And they've just taken off. If you look back over the last 14 years, at least the last 14 years I've advocated, we've never seen anything like this. So to speak to the sunset date, no, I don't think we need to revisit it in 3 years because I don't think we're going backwards. We've only continued to grow and expand, and we need to expand more. I don't see house prices shrinking. I don't see us shrinking in the number of people. So if anything, in 3 years, we may need to expand this protections. There is, as Elliot said, nobody checking on these. I had a family at 360 Dubuque Street that called me up with a renovation eviction and trying to help them go through it. The day they were moving out, somebody moved in. They know this because they went back to get the rest of their stuff and they were too scared to go in because the other people were already moving in. There was no renovating. There was not even paint on the wall on this. I see this a lot. And there's no way, unless somebody takes civil action later, to go back and say, hey, that wasn't a renovation eviction. I have some families that have done the renovation themselves. Rachel Gagney, she would not mind me saying this, and she's asked me to speak about her whenever I get the chance. She renovated with her husband their building, 5 out of 6 units themselves. Turned around when the building was bought and they renovated, evicted them. The people that actually renovated the place. And as maintenance said to them, they were going to paint the walls, replace the stove, add a heater, and that's it. That's not a renovation, but yet it's being used this way. So when we look at the stats, we have 4 to 8 weeks for an initial application for the NHERAP program. That's just a caseworker getting that application and trying to contact them and work through the motions to get them in the program. That takes generally 2 days to a week to happen, that part. And it takes up to 6 weeks for those checks to go out. Landlords are not wanting to use this program that much when a new client is coming in because they know they have to wait for the first month's rent, the security deposit, all that stuff. It makes it harder actually to move with the program when it's this busy because as we've seen with that program, it was having trouble being able to upload everything. So then we have when you're talking about continued assistance after the first initial round and you go back to get more, you're 8 weeks until you get a caseworker assigned to you again. It is incredible waits out there. So you don't even have time to work with those 2 months barely with that. We have 180 people currently in hotels as of the previous date, not today's date, so it could slightly change. Waiting list at shelters. So before they can even get to the hotel, they're going to the shelter, but then they find out they have a waiting list at the shelter too. Where did they go? Warming stations are shutting down. If you notice in your paper, you see a lot more homeless issues on the police calls. Why? Because the warming centers are shutting down and they're having less places to go. And that's where our families will be when they get evicted. It takes a minimum of 2 months to find a place. And we have to remember this is not just an address. This is a home. This is where people have set up their custody agreements. You got to give 60 days notice on a custody agreement when you want to move out of the city. That part hasn't even been raised. So we could be changing people's lives here. A custodial parent could become the parent that sees their kid every 2 weeks instead because of this, because people are casting large nets when they have to move. I would love to hear where Mr. Norman's apartment is because generally I hear of 500 to 1,000 calls on each apartment that is listed. I am guessing, and I'd love to know the answer, I'm guessing it's not in Manchester, Nashua, Concord, or around a big city. And it might be quite high of a rent because the other problem we're having is finding any actual affordable rent because we waited a really long time to start building it. And I am welcome to any questions.
Questions for Ms. Margison? Seeing none? Did you have one, Representative Chase?
Yep. Thank you. And just for clarification, thanks for taking my question. So the Granite State Organization Project, that's not the same as New Hampshire Housing with a voucher? Because you were talking about money that's given to the landlord, but they don't have the first and last month's rent,
That's
so
what-
they're just given the money?
It's with the NHERAP program. They have up to 18 months of rental assistance, and the 1 month security deposit is separate from that. So when they find an apartment, they put their landlord information into their caseworker, and they start the process. That can take about a week usually to have those go back and forth, and then you got about 6 weeks till they get their check. You can ask to expedite it, but that's like 2 to 3 weeks instead of, you know, I mean, expedite, sometimes you think it's really quick, but that's still 2 to 3 weeks. And once they get in, what we're starting to do now is immediately after they go through the program and they get their money settled, what they're going to be paid out, we have them immediately do their continued assistance application because it's so long till they get to the next one. I am actually currently in negotiations with a large landlord in town. I have 6 buildings organized together under one owner because they're all going through evictions right now. That's 6 buildings in Manchester. Multi-unit buildings. So as I explained to them, we got a clog in the pipe and we need to kind of slow it down here. We got to let it trickle through how it's going to and let it open up a little bit. So they're willing to sit down and try and negotiate because this is a lot of hours for them in court also. And if we can get some moved around, but this is the first landlord to ever do this. And that's not common. You know,
Representative Macbeth.
Thank you. What is NAGRE? I may be the only person that doesn't know that acronym, but I just, when we say acronyms, I'm curious.
Right, the which one?
I think you said NAGRE
Oh,
program?
NHERAP, the New Hampshire Emergency Rental Assistance Application Program. Thank you.
Other questions? Thank you, Ms. Margison, for your testimony. Is there anyone else who wishes to testify on Senate Bill 217? I have a question, Mr. Attorney Barry. If you just had another minute, I just have a question, if I could ask
For
it.
you, I always have another.
Well, thank you.
Take 2 if you like.
No,
Okay.
it has to do with it. This creates this new section H. The landlord desires to perform repairs to the dwelling unit, which can't be done safely while the tenant resides.
Right.
Perform substantial renovations or sell the property. And presumably, the landlord, what I've heard here for testimony today is that these conditions may be used as a ruse in certain circumstances. That's what I've heard for testimony.
Yeah, absolutely. I mean, that's happening without the bill. There's no question. As Mr. Norman essentially admitted it, but right? And he says,
Well-
because you have a tenant you want to get rid of, right? But you're concerned you can't prove it. So you say, okay, I'll renovate the property.
Well, and I think that's what my question relates to, and that is the level of proof that would be required at a court in order to satisfy this new section.
The simple answer for you is that, the level of proof is a preponderance of the evidence. But I think normally in the experience that I have right now, I mean, I think what would probably happen is either the landlord, the manager, and or the maintenance people would come in and describe what needs to be done. And, it could be pictures, it could be just, verbal testimony, and I don't think it should be all that difficult.
So and I could just follow up on that, because it seems to me if the issue is that this is being used as a ruse, and that's ultimately what the issue is and why we have to extend the eviction period, why, instead of increasing the eviction period or the notice period, I should say, in each case, addressing the proof that needs to be supplied to the court in these circumstances.
Sure. Let me, if I could, and then I'll address that in a minute, but let me make real clear or repeat what I said at the beginning of my testimony. This, by and large, is not about bad landlords or the people doing this. By and large, it's just to get people the time they need. However, I think what you are suggesting, although as a lawyer I find that intriguing, I think you're probably going to get a lot more blowback from the property owner community than you are with something this easy. But it's certainly something that if the committee is interested, we could work on. But I mean, if you think about it, and this is what happens all the time right now. The landlord simply comes in and says what his intentions are. And it's like, it's hard to prove a negative. Like I come back into the court and say, no, you're not. It's the one thing I have to work with is whether the landlord issued the same eviction notices to the other tenants in the building. But other than that, I got nothing. So, if you can think of a way to enhance that burden of proof, I'd certainly be willing to work with you on it.
Well, and if I could just follow up one more time, and that is, for example, if you want to show somebody's committed malpractice, you can't just come in and say they did something wrong. You need to have an expert in the field say they did malpractice. If you need to show that the repairs are necessary and people can't live in there, it would seem that you ought to have a letter from a contractor saying that it's unsafe for people to reside in there. Or if you're going to sell the house, that the new owner, the agreement that you have with the new owner is that the premises be vacated.
So let me just step back a minute, just so everybody understands. If you give the 60-day notice under this bill, you don't have to worry about it at all. You can still just go in and say, this is my intention. But to address but if you want to go 30, right, and deal with this proof issue here, the difference between this and a malpractice case and almost any other is that it's solely about the landlord's intention, right? And it is very hard to say, well, no, landlord, you don't really intend to do this. It's not about, with a malpractice case or almost any other case, the question is, did X happen or not? It's not, did somebody intend, with criminal cases, you may get into intent, but the issue here is one that in order to get the benefit of this 30-day exception, if you will, you've really got to show that the landlord's intention is not what he says it is. But again, I think in the vast majority of cases, the landlord will give the 60-day notice, the tenants will get the benefit of that, and things will work the way they work now, except the tenant gets more time.
Thank you.
Thank you.
I should ask, anybody else have any questions for Attorney Berry while he's up here? Thank you for second round. Anyone else wish to testify? Seeing no one, we will close the hearing on House Bill 217. And unless there's some other matters before the committee, we'll be in recess until 9 o'clock tomorrow morning.
Under current law, if you say, I have to do a renovation, so you have to go while I do this renovation, there is nothing that gives that tenant priority when that comes back on the market. Right. So no. So even if they could afford the increased rent, they're not given priority.
That's right. There's nothing that I'm aware of that would give them priority.